Okay, Senate Judiciary is in session. Senator Reardon is going to lead us in the pledge. To the flag of the United States of America, to the republic, one nation, under God, indivisible, with liberty and justice. Thank you, Senator. We're going to start off with Senate Bill 142. The Honorable Sharon Carson is going to introduce the legislation. Welcome, Senator.
Thank you very much, Mr. Chairman. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And for this afternoon, I have for your consideration Senate Bill 142 FN, which seeks to establish the Department of Children's Services and Juvenile Justice and transfers the power and the duties of the Department of Health and Human Services Divisions of Children, Youth, and Families to the new department. Mr. Chairman, you know that this is a bill that I have put in before and something that is extremely important to me. But there's a couple of things that have come to, that have happened that I'm going to ask the committee to re-refer this bill to the committee so that I can continue to work on this. The first is the cost. The cost is very expensive, and as everyone knows, we're in a tight budget right now. So we've got to try to work to try to get the costs down. The second is I've been having great conversations with the Department of Health and Human Services about this, and they're more than willing to sit with me at the table to work things out. And that for me is very promising, and I'd like to have the opportunity to meet with them and continue to meet with them to address this issue. So that's why I'm asking you to re-refer the bill back to committee, so I will have the opportunity to do that.
Thank you for your testimony, Senator. No questions.
Thank you very much, Senator.
Patricia Tilley. Good afternoon, Ms. Tilley.
Good afternoon, Chair. Thank you so much for inviting me up to speak today. The department had a number of concerns about Senate 142 as introduced, but as described by Senator Carson, we are very supportive of the opportunity to work with the sponsor and other interested policymakers and advocates to take a more measured approach, exploring strategies that will elevate the needs of children and their families and improve outcomes for everybody. We're very excited to use our new DCYF strategic priorities and an upcoming assessment of our children's system of care to guide that work. And so together, I think we can take a coordinated approach to address the multiple needs of the youth and families, ensuring that the health and welfare needs of the entire family are addressed seamlessly and simultaneously. We want to tailor support for youth and caretakers, leading to stronger families, reduced recidivism, and improved long-term outcomes, especially as we think about the transition from youth to adulthood. And finally, the department has the ability to address the root causes of behavioral health conditions, child abuse and neglect, and juvenile delinquency, improving overall family health, well-being, and reducing the likelihood of continued involvement in the deeper ends of both the child welfare and justice systems. So we want to, again, thank the sponsor. We're looking forward to continued partnership and conversation with Senator Carson and everyone else who shares the commitment to aligning our prevention efforts, scaling helpful community services, strengthening support so that children and youth can stay home in their communities, and reducing the reliance on residential care. We're really looking forward to this opportunity to sit side by side and strengthen all of our children's services, because we want to make it easier for families to get what they need so that every kid has a chance to grow up in a community and a home where they're cherished, they're cared for, and have all of their health and wellness needs met. So we've made some great strides and we're looking forward to doing more. Thank you.
Thank you, Ms. Tilley. Seeing no questions, have a great day. Holly Stevens. Good afternoon.
Good afternoon, Chairman Gannon, members of the committee. My name is Holly Stevens. I'm the Director of Public Policy for NAMI New Hampshire, the National Alliance on Mental Illness. Given the sponsors' request to have this re-referred, I'm going to make this very brief and just say that there's two concerns that we outlined in our testimony, which I will let you read instead of me reviewing it. And those are the transition from youth services to adult services, that it's already a difficult transition when the departments are under the same roof. So separating them would make that transition even more difficult, and also the cost, as you've heard about. So with that, I will conclude my testimony, and I'm happy to answer any questions.
Thank you very much. Seeing none, thank you.
Thank you.
Tracy Fowler.
Just press that button. Okay. Good afternoon, Committee and Honorable Chair Gannon. My name is Tracy Fowler, and I'm with the New Hampshire Charitable Foundation. Considering the sponsor's recommendation to refer back to committee, we'll also keep our testimony brief today, and you can read in our notes. Essentially, we also had some concerns about this bill, which I think will get addressed in the further discussions. We were here today in opposition of SB 142. We were deeply concerned that it will lead to unintended negative consequences for kids and young people. We don't want to see years of careful work to integrate services undone. We respectfully suggest that the significant funding would be that there would be significant funding needed to stand up a new department, and it could be better invested in sustaining and strengthening existing statewide infrastructure and community-based services. And so I'll sort of keep it there, but we have more in our testimony, and I also wanted to offer the Charitable Foundation's partnership, again, to become, to be part of the table discussing further recommendations and ways to improve. We've been sort of arm in arm with the department and community partners for many years, working towards a better service array for kids and families. So we're happy to continue that work.
Thank you very much. Seeing no questions, have a great day.
Thanks so much.
Does anyone else wish to testify who didn't sign up on 142? Seeing none, the hearing's adjourned. Motion to go into an executive session. No, we're not going to do it with two. Okay. They're on their way. That's good. Thank you. Sounds good. Not always. Yeah.
Big chair. I'm not sure about her.
make a motion to move into executive session. It's just going to be, you don't even have to take anything out. No, we're going back to SB 142. I have a motion to re-refer. Any discussion? All in favor? Aye. Okay, ayes have it. I'll take it out. Anything else, Pete? We all set? Motion to, what's that? I can't hear you.
Are we consenting?
Oh, motion for consent? 3, all in favor? Aye. Okay. And I'll take it out. Thank you. And motion to move out of executive session. Al second. Okay, seconded. And all in favor? Aye. Aye. Okay, we're moving back to schedule. We're going with 248. Sorry to keep you, Senator Rishardi. You take it away.
Okay, well, good afternoon, Chairman Gannon and members of the committee. For the record, my name's Denise Rishardi. I'm the state senator for District 9. I have 13 towns from Bedford to Hinsdale. Today, I am pleased to bring before you Senate Bill 258 relative to the crime of fraudulent retail transactions. This past fall, I was able to take a tour of the Bedford, New Hampshire Lowe's home improvement store. During the site walk, I was informed of a growing problem: retail gift card fraud. I was amazed at the level of sophistication these organized retail crime rings use to steal, manipulate, and steal again from hardworking Granite Staters when they purchase gift cards for family members, friends, and colleagues. It is important to note that for the last 17 straight years, gift cards are the #1 most requested holiday gift, and consumers are increasingly vulnerable to scammers who tamper with and drain the accounts of gift cards, leaving customers frustrated and our New Hampshire retailers on the hook for lost funds. Let me begin with giving you a basic understanding of what is being done by these organized retail crime organizations. First, they send in takers to steal the inactivated gift cards right off the shelves. Then, transport those gift cards to a centralized location where experts tamper with the activation barcode and repackage them, leaving no trace of any manipulation. Then the placers go back to either the same store or another store and replace them back on the shelves. Once a customer chooses a gift card to purchase as a gift and it is activated, there are checkers, oftentimes overseas, constantly monitoring the balance of all of their tampered gift cards. And once notified it has been loaded with money, they drain it. The recipient of the gift card then goes to use the gift card only to find the balance is 0. When approached with this issue, a retailer will provide a refund to the customer. But the damage has been done, and these organized retail crime organizations already have the money. While this practice is happening across the country, and especially the Interstate 95 corridor, New Hampshire is particularly vulnerable due to our sales-free tax status, where the scammers then use the money to amass goods, which they can then ship in mass quantities overseas for resale on the black market. The legislation before you was designed by the Black Hawk Network in conjunction with the Project Red Hook, which was started in 2024 by the Department of Homeland Security. The amendment before you today reflects extensive work and meetings with Black Hawk Network, New Hampshire Retail Association, and New Hampshire Attorney General's Office to ensure that this bill provides the tools law enforcement needs to combat this practice and protect our consumers and retailers. We are lucky to have the president of the New Hampshire Retail Association here today to tell you a little bit more about the problem and how this legislation will put New Hampshire at the forefront of the country in addressing this issue. I ask the committee to recommend this bill ought to pass with the amendment I presented and send this bill to Governor Ayotte as soon as possible. Thank you so much.
Thank you, Senator. Any questions? Go ahead, Senator.
Thank you, Mr. Chair. Thank you, Senator Rishardi. I'm looking at the replace all amendment that you brought in, and this is actually moving, your original bill was an amendment to RSA 637.10, and this is now amending 637.2. And because I'm just seeing your amendment for the first time, can you walk us through the differentiations? I was prepared with your first.
I am going to let the Attorney General do that, as I am late for transportation, if you don't mind, as long as your question gets answered.
Terrific. Thank
Okay,
you.
thank
Thank you,
you.
Senator.
Yeah,
Have a great day.
got it.
Brendan Gerard. Good afternoon.
Good afternoon, Mr. Chairman, members of the committee. My name is Brandon Garrod. I am a Senior Assistant Attorney General at the New Hampshire Attorney General's Office. I'm also the Chief of the Consumer Protection and Antitrust Bureau, and we are here in support of Senate Bill 258 today. Prior to my time in the Attorney General's Office, I was an Assistant County Attorney with the Rockingham and Carroll County Attorney's offices, where I really learned to cut my teeth as a criminal prosecutor and learned about some of the struggles that are involved in making new trends in crime fit old statutes. And I think that is the key to why the Attorney General's office is here in support of this bill today. This bill does not do anything revolutionary. It doesn't do anything complex. All it does is account for the reality that the way theft has been modernized to involve gift cards, as Senator Ricciardi described, there are difficulties for criminal prosecutors in fitting that specific crime into our current theft statutes. And I'll give you a couple examples of what I mean by that. Our theft statutes as they exist use a structure that you utilize the value of the property that was stolen in order to determine the level of the offense. If it's more than $1,000, it's a Class B felony. More than $1,500, it's a Class A felony. Anything less than that is a misdemeanor level offense. There's a real struggle in that for prosecutors if they were to, under our existing statutes, see a case referred exactly what Senator Ricciardi described. Somebody goes into a store and they're caught tampering with a gift card for the purposes of somebody later stealing the balance of that when it's purchased and activated by somebody later. The question is, what has been stolen and what is the value of it? What was stolen is the information from the gift card. Information doesn't inherently have value. Some gift cards don't even independently have a set value. Sometimes they can be anywhere from $5 to $500, depending on the amount of money that a consumer chooses to put on them. This bill addresses that issue and provides a clear structure for prosecutors and law enforcement, if they receive reports of this crime, to clearly understand what the value of the stolen property is and understand how to charge it in a manner that is effective and will hopefully both deter this crime from happening in the state and hold those who are caught doing it accountable for their actions. So I can preemptively try to answer the question about the reason for the switch in the section from 637.10 to 637.2. So the reason for that is, as I just described, the entire theft chapter, 637, has definitions that apply throughout. And those definitions allow for the use of any of the theft statutes to incorporate those definitions in the event that the specific crime fits the specific variant, whether it be theft by misapplication, theft by deception, theft by unauthorized taking, or in this case, crimes involving gift cards. So there were amendments to the definition section that were necessary to make sure that the definitions that were incorporated in this new crime were also applicable to all of our existing theft crimes. If somebody were to commit a different type of gift card fraud that was unanticipated by this specific statute, they would still be able to use those definitions to be clear that what was stolen either is a gift card or how to determine what the monetary value of that information is. So I think that is the extent of my testimony. I think that this is a reasonable approach that will give prosecutors and law enforcement a better opportunity to hold people that are perpetrating this type of crime accountable for these actions in the state. I'm happy to take any other questions that anyone might have.
Just a quick question, and I think it's probably explained in the amendment. So if someone stole 4 gift cards, so we can value them at the highest value each at $250, we'll just say, now I get a $1,000 Class A felony if you stole 4 cards.
It would depend on the value of the card.
So if the max, they don't have any value to some of them. till they, you issue whatever value, 50, 200, 250, whatever.
Mhm.
So when there's an indeterminate value, I think in the statute here, it says the highest possible value of the card, correct?
That's right.
So we'll just say it's the 250, so you steal 4 cards. Now you've done a Class A felony, correct?
That's right.
Okay, I understand. Thank you. Any other questions? Seeing none, thank you very much for your testimony. Mike Summers. Are you here, Mike? Someone else wish to testify for him? No. Does anyone else wish to testify on 258? Welcome, sir. State your name for the record.
Good afternoon, Chairman Gannon and distinguished members of the Judiciary Committee. My name is Curtis Picard, and I'm President and CEO of the New Hampshire Retail Association, here to testify in support of Senate Bill 258 relative to the crime of fraudulent retail transactions as amended. I appreciate Senator Riccardi for putting this bill in and the support of the Attorney General's office. As you've heard, a lot of work has gone into this bill. I'm not going to read my testimony for you, but I did want to point out 2 things that I did attach to it. One is an infographic that really explains graphically how this type of crime is happening. And then at the back of my testimony is a press release from the U.S. Attorney's Office here in New Hampshire about a recent case involving this type of crime. So as you've heard previously, a state like New Hampshire is particularly vulnerable to this type of crime because of our sales tax free status. They like to get the best bang for their buck out of these stolen goods. So they redeem the gift cards here, ship the goods overseas, and that's the crime that's happening. But through 90% of the way through this crime, there's no value attached to the gift cards. It's only once they're activated. And this is what this legislation seeks to fix. So I'm happy to stop there and answer any questions you may have.
Any questions? No, clear to me. Thank you.
Thank you.
Does anyone else wish to testify on 258? Seeing none, we'll adjourn the hearing. Do you guys have any questions on this? We'll go right into exec. Do we have time, Pete? Yeah. Motion to go into. I'm sorry. Thought it was clear, so. Motion to go into executive session.
Second.
Thank you. Any discussion? Motion about to pass.
Second.
And, all in favor of the motion? Oh, I'm sorry.
Wait, do you want to offer the amendment?
Yes. Thank you.
Sorry, Mr. Chairman. I know
Thank
you
you.
need to
No,
speak
no,
up.
thank you.
I still apologize.
That's okay.
I like that. And that's amendment 2025-0428S.
And any discussion? I'm seconding. Seeing no discussion, we'll move the amendment. To pass.
Oh,
All in favor?
aye.
Aye. Opposed, none. Motion for consent?
No, now do ought to pass as amended.
That's clear. To pass this amendment? All in favor?
Aye. Move can consent?
Second. All in favor?
Aye.
Ayes have it, thank you. Does anyone want to take it? I'll take that.
All right.
So we get 2 minutes. You're already there. I look up and you are. Okay, motion to go back into session. Did we already?
Motion to come out of executive
So
session?
that would be proper. Second. All in favor?
Aye.
Senator Waters, welcome to Judiciary, and tell us about SB 290, and I look forward to hear about torture of animals. Go ahead.
Thank you, Mr. Chairman. I'll try not to torture the committee with the bill on torture. This is Senator David Waters from District 4 to introduce Senate Bill 290 relative to the definition of torture in animal abuse cases. You can see before you The definition in this section, torture means negligent or purposeful act or omission that causes intense or prolonged pain or suffering, causes serious physical injury, and causes death of an animal due to such negligent or purposeful act or omission. This language resembles that in most of the states that have this kind of definition of torture in their cruelty statutes. It is similar to the ones that are in Maine and in Vermont. The three largest agricultural states with the most livestock in the country, California, Florida, and Texas, all have versions of this as well. So it's language that is tried and tested in a lot of states. And the reason why it's coming before you is that the Governor's Commission on the Prevention of Cruelty to Animals, on which I serve, has looked long and hard at section 644:8, which contains all the abuse, negligence, and torture statutes, and found that this was, cobbled together over many years of legislation. And they felt that from what they had heard from law enforcement, that if you look at the sections here, where they will use the phrase in several places, negligently beats, cruelly whips, tortures, mutilates, or any other manner of mistreats, and it causes any animal to be beaten, cruelly whipped, tortured, or mutilated, that the law enforcement said, well, there is not a definition of torture here, so that we do not know how to proceed. This is what we heard from the law enforcement representatives on the commission and from officers connected to the Humane Society and elsewhere. So the commission chair went to Governor Sununu and asked, to the way that commission is set up by executive order, there has to be permission from the governor to take action. And they went to the governor and asked, can we develop a definition of torture? He said, yes, you should do that. So last summer we met and spent a lot of time on getting the language here so that it would be sure to not, creep up to involve consequences for people who are not endeavoring to negligently or purposefully cause these acts. Now, I do encourage you to look carefully at the entirety of 644:8, because you'll see the way it's constructed, that it ensures that when we're talking about causing of pain and so forth, this is not going to be applying to veterinary practice or to other kinds of practice. Do note as well in the section 644:8, section 4, there is a particular procedure that if it involves livestock, that the officer must be accompanied by a veterinarian, because a veterinarian is going to know better than some law enforcement officer about whether or not an animal is actually being mistreated. Now, I know there is some concern about the application here to farm animals. I think looking at all the other farm states that have passed something, I think there's a way, the Texas model, maybe if we have to think about some further guardrails around whether this would be applied to agricultural operations. I mean, believe it or not, having worked on a horse farm 55 years ago, I know about certain kinds of bits that are necessary sometimes for training, and there are some issues there. So the point here, and this is why the words are used, you can see we chose negligently because it's defined in 626:2, culpable mental states. A person acts negligently with regard to a material element of offense when he fails to become aware of an unjustifiable risk that constitutes a gross deviation from the conduct that a reasonable person would observe in a situation. And then purposely, also defined in 626:2, a person acts purposely with respect to a material element of offense when his conscious object is to cause the result or engage in the conduct that comprises the element. So those words were chosen carefully to make sure that we do here get at, as in the other horses here, beaten, cruelly whipped, or mutilated, behavior that is clearly intended to torture, and the definition of what that torture means. I have distributed to you a letter by Jerry Zazula, who is the chair of the commission. She couldn't be here today, but she wanted to have here the origins of the bill, why a torture definition, and what the commission has done, what it brought to Governor Sununu. It also gives you some case examples there of the kinds of things that, that could potentially be involved here. And she invites with more particular questions to get in touch with her. I think just for practical matters that this definition is something that we need because it's in statute. The word torture is there. And unlike some of the other areas, we don't have a definition of it. And this, I think, actually provides more protection to people because if we have a definition, then they can't be inadvertently charged because this does escalate up from misdemeanor to felony. If there are certain, you'll see how the statute's constructed if you look at 644(8). And as I said, I looked very carefully to try to make sure that we had appropriate guardrails for veterinary practices. I mean, there's some things cause pain to animals, right? And it's necessary part of treatment, or what pain in terms of treatment in one person, is a standard agricultural practice really is not unjustifiable, is not torture. But if there's a need to come up with some more language, I'm glad to work with Senator Pearl and Farm Bureau and others to do that. But our surrounding states do it, and I think that it's going to help clarify some things for law enforcement. It comes to you as something that we developed because Governor Sununu gave us the go-ahead to do it. I have to get back to finance, but I'm glad to start with any questions. I know there are other people here who
Senator
have talked to.
Assessment.
So, yeah.
Thank you, Mr. Chairman, and thank you for taking my question. Just from a statutory construction language here, I always consider torture to be something that's an intentional act. So I guess by having negligent in there where the person should have been aware of what they were doing would create a risk, but they weren't. It's not something that basically they're ignorant to what they're doing and they're creating a risk that results in harm to an animal. But should there be a distinction between an intentional act and a negligent act?
Well, we have negligent or purposeful act or omission. And a lot of, the omission one, I think we can kind of all get, like if you don't give an animal food, right, you starve them to death, or if you leave them out, dog out when it's 20 below zero, no shelter, those are omissions. Maybe they're negligent as well, because you would, have conducted behavior. I think the purposeful is important here. So, but we have, all three there because I think of, looking at those, the negligence and purposeful in other parts of statute, it seemed like I saw these words as providing some real tight guardrails that, these are behaviors and categories, I think, that reflect either a kind of a negligence that one should know better, clearly, and there are, as you know better than anybody else, there are standards for that when you choose to prosecute or not. But that, that this is behavior that is purposeful. So that's why we came up with that language there, and it's very much like what other states have too.
Well, but leaving a dog outside in negative 20-degree weather, I mean, that's purposeful.
I couldn't quite understand.
If you leave a dog outside in 20-degree weather and the dog suffers injury or dies from the elements, that's purposeful, isn't it? The act itself was done purposefully. I guess the question is, like, for negligence, it's kind of it's really an accident. It wasn't something that the result wasn't intended.
Well, thank you on that. And I think, as again, you know better than I. But I would say that purposeful might mean you leave the dog out there in the cold because you want it to suffer. All right? Negligence would mean that a reasonable person ought to know, I mean, as I read that definition, that if you leave an animal out in that conditions. Now, and I think those are two standards, right? And that's why that we have both negligent and purposeful in statute. So that, again, you're involved in cases. You know how you've got to slice and dice and decide what's appropriate charging for something. But right now, we have nothing in statute that provides a definition.
Thank you.
Yes, Senator.
Thank you, Mr. Chair, and thank you, Senator Waters, for taking my question. With regards to negligence, would a person who has a wounded animal and does not tend to that wound fall under negligent for not tending to the wound?
I think if you look at other, I'm trying to see. Where it is else in this. I'm not exactly sure that
Can I follow?
there's a differentiation there.
Okay,
I think in 644.8, I'll look, but I think that kind of circumstance is covered elsewhere.
I think we may have answered my question from Senator Abbas that in your proposal, active or omission would be its own standalone as part of the definition. But would you believe in my town, we actually had exactly this situation where a dog owner had dogs that were his hunting dogs, and he built them beautiful pen in his backyard, close to the house, well-fed animals, hunted with him for years. And we had, during the ice storms, I believe it was 2011, the neighbors were very concerned because the dogs were outside and barking and seemed to be in distress. And through a conversation with the law enforcement and representatives from an animal welfare organization, recognized that this gentleman truly believed that his animals were bred to stay outside, even in the throes of what turned out to be a rather deadly ice storm in our area. However, also recognized that perhaps the police and the neighbors and the animal welfare organization may have a little something to add to his add to the way he took care of his animals. And he eventually agreed to let them stay in the garage.
Yeah.
So would that fall under,
Excuse me.
no worries, that happens.
If I may just comment on that. If you look at 644.8, you'll notice that there's a shelter section or necessary shelter. And I think that is covered elsewhere within 644.8. There are a lot of things in 644.8. As I said, it was cobbled together in many ways over many years.
Mm-hmm.
The one omission here for law enforcement is to provide a definition for torture, because it is there in statute in a few places. And it may be behaviors. It says, negligently beats, cruelly whips, tortures, mutilates, or in any other manner mistreats or causes to be mistreated any animal. So the one that sticks out there is torture. Now, will this be used or not? That's going to be always up to law enforcement to make the determination as to what charge and what is possible and what's provable. But it may be that certain behaviors, would clearly be a negligent or personal act that causes intensive or prolonged pain or suffering, causes serious physical injury, or causes the death of an animal. See, that's what we're getting at with torture. Now, you might not whip the animal to death, right? And you might whip it once, and it might. So, is that prolonged pain or suffering? Does it cause serious physical injury? Maybe not, right? So in a given incident, but here, the notion of torture, which is prolonged, serious, causes death, that's what's going to be under torture.
Seeing no other questions? Thank you very much, Senator. Joan O'Brien. Unless Senator Pearl, you're not here, are you? I'm sorry, Senator Pearl. Senator Pearl, you'll come first. Didn't see you.
Thank you, Mr. Chair, and good afternoon to the committee. I am, for the record, Senator Howard Pearl, and I am here to oppose the bill as written. So I have some very strong concerns about the unintended consequences of looping in accepted animal agricultural practices into this torture definition. And you know, as much as I respect my colleague from District 4 and him bringing this forward, I think it opens up a conversation about, you know, other areas of the statute that you've been talking about. There was, you know, while it's well intended to have all of these things in statute, sometimes in practice, that's not what actually happens in the field. And, you know, my colleague mentioned you know, about having to have a veterinary present. I can tell you that there are just a case recently where that didn't occur. They didn't follow the actual practical application of the law, and it ended up in some farm animals being euthanized unnecessarily. And that is always my concern when you start moving into these areas of putting definitions in law. I'm just really concerned about what you're sweeping in. And again, we have many practices in agriculture to the average person, they don't understand how they work or why they work. But having spent my life in this field, I would just tell you that I think we've been okay without this definition of torture, and I think we'd be okay right now without it. You know, I think the statute itself that has plenty of things in it already that we have worked on for many years. I spent all of my house years in environment and agriculture, and we worked many times on this chapter of law, and I think it's in pretty good shape where it is. And I guess I would encourage you to be very careful about moving forward with placing this definition. So thank you.
Thank you, Senator. Any questions? Seeing none, have a great day. Thank you,
All
sir.
right. Thank you.
Stacy Ober.
Good afternoon, Mr. Chairman, members of the committee. My name is Stacy Ober. I am the New England Government Relations Manager for the American Kennel Club. We are a 140-year-old not-for-profit animal welfare organization. We represent more than 5,000 clubs across the country with 13 affiliated clubs here in New Hampshire. Just to give you a little bit of information about the American Kennel Club, we've funded more than $68 million in canine health research benefiting all dogs. And in addition, we support many community benefit programs such as the Adopt a Canine Cop grant that placed 2 working police canines to help police departments in Berlin and Portsmouth serve and protect. I wanted to talk about how Senate Bill 290 would describe an act of torture for purposes of bringing animal cruelty charges as, quote, any negligent or purposeful act or omission that causes intensive or prolonged pain or suffering, causes serious physical injury, or causes the death of an animal due to such neglect or purposeful act or omission. This is a novel and expansive description of the word, and it may be very well intentioned, but it differs from how it is used in current RSA 644.8. Under New Hampshire statute, it's acts that are motivated by an intent to cause harm, or on the misdemeanor section, my interpretation is acts that have a reckless disregard for harmful consequences. So a level of negligence that would be considered gross negligence done with reckless disregard, if not purposeful. And that AKC is opposed to Senate Bill 290 because it would likely result in inappropriate criminal charges for purposely taking or not taking lawful actions that, even for those beyond one's control, could result in harm. And I've provided for the committee in my written testimony a list of buckets, so to speak, of where we believe the law, if adopted, could be misinterpreted and have a chilling effect on these lawful activities. So I appreciate the sponsor noting that he didn't believe, for instance, that this would interfere with veterinary practices. Because I cover New England, I'll share with you a recent case in Rhode Island in the news where a veterinarian had mistakenly left a hemostat in the abdomen of a dog, a St. Bernard that suffered for 2 years before they figured out that, in fact, this act of negligence had occurred. So although the individual maybe disciplined by the veterinary board and whatnot. Under this particular, as introduced language, that veterinarian could be criminally charged with torture. So I give you that one example. So actions that are taken if there is a reasonable fear of imminent attack by someone that would be a purposeful act that perhaps could result in injury or serious harm of an animal. Conduct which is permitted under the agricultural or animal husbandry laws, which Senator Pearl just referred to. Conduct that is permitted under the laws, custom, or practices of this state or the United States related to the breeding, training, conditioning, and use of animals for rodeos, equine activities, livestock shows, field trials, and similar activities. All of us have heard the unfortunate situation at the racetrack, for instance, where the horse goes down, breaks a leg in that event. If they had to euthanize the animal, would that not be subject to criminal charges under this definition? In our estimation, it could also be used for a situation where you were using a dog for hunting, for law enforcement. Senator Carson's not here, but she shepherded through the general court 2 years ago the emergency treatment and transport of police canines, knowing that they are purposely released in the field to apprehend suspects, and unfortunately on occasion do suffer serious injury or even death. I covered veterinary practice. Any alteration or destruction of an animal done by any person or unit of government pursuant to statute, ordinance, court order, or the direction of a licensed veterinarian. So I'm talking about euthanizing a dangerous dog, for instance. Or conduct that's lawfully taken under the laws of this state or the United States relating to activities undertaken by research and education facilities and institutions. So for these reasons, AKC believes the definition, and I've looked at other states' laws, that this is a novel and very expansive definition, and we're opposed to it being adopted and would appreciate your consideration of these concerns.
Thank you, Ms. Silber. Go ahead, Senator.
Thank you, Mr. Chair. Thank you very much, Ms. Ober. So I have your testimony, and I'm curious. So under Senate Bill, the proposal of Senate Bill 290, you have in your testimony, the testimony you just gave, that there's a fear that this will have a negative impact and a chilling effect on lawful, worthwhile activities. And under number 3, you have conduct that is permitted under the laws, customs, or practices of this state related to breeding, training, conditioning, and use of animals for rodeos, equine activities, livestock shows, field trials, and similar activities. Under that section, section 3, what's happening now that could be misconstrued as torture? Like, are there practices that are happening now?
Well, I think that's why I gave you a specific example of rodeos. So I'm talking about any of these lawful activities where people are purposefully engaged in activities with their animals, but serious injury could occur, only because you're not in control of every circumstance that might happen. So let's just suspect. Let's say I go out hunting with my dogs, and unfortunately the dog gets shot by one of the other hunters out in the field. Purposely out there hunting with my dog, there's a situation where the dog gets hurt. I think the language would create a chilling effect on anyone feeling comfortable that any act or omission they might take that could be considered neglect, because that's exactly the word that's used in the bill. I'll read it again. Any negligent or purposeful act or omission that causes intensive or prolonged pain or suffering. So there are situations where you maybe have a responsibility to do certain things, like I gave the veterinarian example, but an animal could get hurt, and it could be considered negligent, when I think the current law as written in the misdemeanor section refers to negligent conduct. And when it refers to torture in that subsection A, as an attorney, I suspect it likely is referring to a level of negligence that would be considered gross negligence or wanton disregard. So all of us heard, for instance, that, or maybe you didn't, but I did because I see all the news relative to dogs. When people were evacuating in Florida, there was an allegation that people had left dogs tied outside and then left and evacuated without their animal. In my opinion, that would rise to a level of wanton disregard. Someone who ought to be able to foresee that that would result in torture to any animal that would be left behind with a hurricane coming and being left in danger like that, if that's helpful.
Thank you. May I follow up?
Yes, you may.
So, in looking at the statute as it stands right now, I want to be transparent that I want to, bring you along in my thought process and hope that you can help me, understand your position. I see the statute, and in the statute, which admittedly from prior testimony we have heard did not come about in its entirety all at once. It's been added, subtracted, it's been hobbled together over the course of many, many years. That said, the reason it gets hobbled together over many, many years is that cultural practices and the way we understand the way animals feel pain or the way that we treat animals has changed over the years. So I'm looking at 644-8, right? And we have B, which is where this bill will add in the word torture. And it has negligently beats, cruelly whips, then possible, maybe, adding in torture, mutilates, or in any other manner mistreats or causes to be mistreated by any animal. So my question is, as we're approaching this right now, is this not just the natural evolution of our laws in the way that we care and treat animals, since we have seen fit to describe whipping an animal as whipping versus cruelly whipping, mutilating, or otherwise abusing? We've changed the way we talk about the care or treatment of animals. Is this not just the next step in our evolution?
I think, that's a question for the general court. As I look at the statute, the only words that are defined in the statute is the word animal and the word cruelty. So mutilates is not defined, cruelly whips is not defined, and I believe that as written, a court would interpret torture consistent with its ordinary meaning and what the dictionary says. And when you look at the word torture, it typically refers to intentional, knowing, and willful, unjustifiable, for purpose of causing suffering or harm. So I don't agree that changing the common understanding of the word torture is an appropriate act. But if the court and this committee felt as though there was some verb that was missing from the statute, clearly you'd be free to add it, as you're reflecting on the process of it being amended over time. But I've hopefully given you examples of where someone might be engaged in lawful activity that's purposeful and could result in serious suffering of an animal, not intended, not knowing. And then other examples where someone might be negligent, not rising to the level of complete wanton disregard for the consequences of their act or omission. I'm hopeful that's helpful.
Thank you. Any other questions? Thank you very much for your testimony.
Thank you for your time.
Kurt Ehrenberg, sorry about that.
Thank you, Kurt Ehrenberg, New Hampshire State Director, Humane Society of the United States. So I think Senator Waters made the case very well. I would just say that if you look at it from the animal's perspective, if you're being tortured, it really doesn't matter if the person did it negligently or purposefully. But I think to answer the question on negligence is that it does belong here because it is part of a way of torturing the animal, and it does belong there, I believe. I know there are other people that want to testify on this bill. I'm happy to take any questions, but we're clearly, and I am a member of the Governor's Commission on the Humane Treatment of Animals. So that would be I'd be the third person on the commission testifying in favor of this today, if you include Dr. Zazula, who is one of the co-chairs of the commission, and Senator Waters. I think Governor Sununu and Governor Ayotte are in support of this, and we'll continue to support anything that helps animals in this state, and I hope you will too.
Thank you. Go ahead, Senator Abbas.
Thank you. Thank you, Mr. Chairman, and thank you for taking my question. I hope you still agree with me after I ask this, but I've always considered myself, a friend to animals. But my only concern with it's not the intent of what I think defining torture under the law isn't the problem, but it's perhaps maybe the language being used might go beyond that. And I'll give you an example. If I'm just driving in my car on a public way, going 35 and 30, so I'm technically speeding. If I were to hit, a domesticated animal, and whether it was severely injured or the animal died, my read of this is I would fall under the torture definition and technically be charged with a misdemeanor, despite having no intention, despite stopping. Obviously, I would feel very bad about what happened, but at the same time, I'm technically violating the law. So I think the concern is perhaps the definition being proposed, not the intent of what we're trying to accomplish.
Well, I mean, I would think we're not talking about allegations here. We're talking about proven cases, right? So you'd get a defense lawyer and you'd go to court. I mean, so it's a matter of we're not talking about allegations. So if you are not guilty of torture, then you could prove that in a court of law. The definition, I think, belongs here.
Go ahead and follow up.
So my point is, and I drafted this legislation that would require the reporting, to the owner, to the authorities if you hit someone's cat. I was the prime sponsor of that. And that person, I think that I stand by that legislation. But by them reporting it, they're essentially admitting, that they did it. They're not trying to hide it. But they did cause the death of an animal through a negligent act. And I feel like in that scenario, they would technically, under the definition of torture as it's proposed in the original draft, they could be prosecuted. Now, I don't think that's the intention. I'm not clear that's the intention of what the Senator Waters have.
If you're asking if you amended the bill to take out the word negligent, would we still support it? Yes.
That's not what I was asking. But what I'm saying is, if in that case, you've already admitted what you did, it was just, an unfortunate situation, an accident, right? They still would be charged. So I guess my concern is, if we just took the ordinary definition of torture, which I pulled it up, this is just from, dictionary.com. So the action or practice of inflicting severe pain or suffering to someone as punishment or in order to force them to say something or do something. I'm just saying in that case, you're the type of harm that you're doing, it's done with an intent to compel some type of behavior. So if we maybe narrow the definition of torture, would that be something you would be supportive of?
We like it the way it is, but we certainly want legislation that, I mean, the commission wants it, my organization wants a definition of torture in the statute. This is acceptable to us, but I would certainly be willing to look at any amendment. Thank you for your interest in that.
Anyone else? Seeing none, thank you for your testimony.
Thank you.
Angela Ferrari. Good afternoon, Ms. Ferrari.
Good afternoon, Chairman, members of the committee. I do have some copies of my testimony. Send them via email yesterday. For the record, my name is Angela Ferrari. I am here on behalf of dog owners of the Granite State. Just a quick introduction on the organization. We are a nonprofit representing New Hampshire pet owners since 1991. And our members include breed clubs, kennel clubs, veterinarians, breeders, mushers, hunters, and livestock guardian dogs, to name a few. And we're all committed to responsible animal care. I think it goes without saying that we do not condone torture. However, SB 290 attempts to criminalize actions that are already illegal while creating unintended consequences for responsible animal husbandry. Existing statutes that are in law already prohibit depriving animals of necessary care, sustenance, or shelter, which I think we touched on with talking about leaving dogs outside. Beating, cruelly whipping, torturing, mutilating, or mistreating any animal. Overdriving, overworking, or otherwise abusing animals used for labor. Transporting animals in a harmful manner. Abandoning animals without proper care. Or subjecting animals to cruelty, inhumane treatment, or unnecessary suffering. If passed, this bill could lead to unintended legal risks for responsible pet owners, livestock managers, conservationists, veterinary professionals. Laws should not be based on emotionally driven assessments. Poorly defined terms may result in arbitrary or activist-driven prosecutions rather than objective legal standards. New Hampshire law already references torture in several places without needing to define it. Some examples, and I have the sections listed, I won't read out all the numbers, but we do have treatment of horses in there. But outside of animal RSAs, we have exposing minors to harmful materials where torture is listed, homicide for procedure and capital murder, criminal code for child sexual abuse images, and obscene matter under general provisions, all of which reference the word torture without a definition being necessary in order to proceed with prosecutions. Additionally, no federal animal cruelty law defines torture, yet enforcement remains effective under existing statutes. Key federal laws include the Animal Welfare Act. They regulate animal treatment but does not define torture. The PACT Act criminalizes extreme cruelty but avoids using the term torture. Humane Slaughter Act requires minimizing suffering without defining torture. And the Endangered Species Act, which protects animals but doesn't use a definition of torture. The closest federal reference is the PACT Act, which does prohibit extreme animal cruelty, including crushing, burning, drowning, suffocating, impaling, sexual exploitation of animals, and creating videos of extreme abuse. I think this speaks back to Ms. Ober from the AKC's point where she mentioned maybe there's additional verbs that are missing from our current law, but not necessarily a need to define torture. So although torture is not explicitly defined, courts have already interpreted cruelty and inhumane treatment effectively. A few reasons why defining torture is problematic: legal inconsistencies, different states, and as was mentioned earlier, there are different definitions of torture out there. And with those different definitions of torture, it could lead to confusion in enforcement. Potential misuse, vague definitions could be used to criminalize legal activities, which we talked about, such as hunting, veterinary care, livestock management, general animal husbandry. And it's difficult to amend. Poorly written definitions are difficult to revise later, potentially harming responsible pet and livestock owners indefinitely. A few additional challenges with this bill are subjectivity. There is no universal standard for what constitutes intensive or prolonged suffering. There can be enforcement inconsistency. Different judges may interpret severity differently. And short-term versus long-term pain. Would brief acute pain, certain training methods, for example, qualify as torture? So in conclusion, we urge the committee to vote SB 290 inexpedient to legislate. No definition is better than a bad definition, allowing courts to continue applying existing animal cruelty laws appropriately. And I would thank you for your time and would take any questions.
Thank you for your testimony. Do we have any questions? Yes, go ahead, Senator.
Thank you, Mr. Chair. Thank you very much for taking my question. So in your testimony, you just said this would possibly prohibit natural instances of animal husbandry. In what part, like, could you be specific
Sure.
about what you're concerned this
Sure.
would eliminate from whatever it is you're doing?
Sure. So for an example, and this is a little bit more agriculture, but can still apply to dogs, a lot
Okay.
of the
Because you're the dog, you're
dog owners of the
representing
Granite
dog
State.
owners. So,
Yeah.
yeah, maybe just
Pet
stay in
owners.
your lane.
Sure.
Yeah.
Breeding dogs, oftentimes they have their puppies at home, not necessarily always at a vet's office if we can avoid C-sections, things like that. There's occasions where there could be a stuck puppy that you need to get involved with helping to remove from the mother dog so that you wouldn't have loss of life of her. Now, that could be painful. There could be some brief suffering during that process. Is that something that could be defined as torture within and purposeful even for going in to remove that puppy? Now, everyone would initially say, bring your dog to the vet at that point, have the veterinarian remove the puppy, remove all concerns of responsibility and torture to the owner of the dog. However, in doing so, you may not make it to the vet in time for the veterinarian to remove that puppy to save not only the puppy, other puppies within the dog, but also the mother could die as well. So there are interventions that need to happen in general animal husbandry when it comes specifically to dogs that I think could be scooped up in this.
Thank you.
Thank you very much for your testimony.
Thank you.
Robert Johnson. Good afternoon, sir.
Good afternoon, Mr. Chair and members of the committee. For the record, Rob Johnson, representing the New Hampshire Farm Bureau as the Federation's policy director. Farm Bureau as a federation consists of New Hampshire 10-county Farm Bureau organizations. We're made up of just under 2,500 members, consisting of family farmers, organizational supporters, and general business affiliates. And we oppose Senate Bill 290. I'm going to start off kind of getting to Senator Abbas's initial question. That by definition, torture is understood to be an intentional act, requiring thought. And you look it up, and one of the fundamental elements of torture is intentional. We asked why this bill is necessary. It addresses, as has been said previously, addresses actions that are already illegal while creating questions around common animal husbandry practices, and to give examples in that area. And I'll speak from more my knowledge base, and that would be cattle, particularly beef cattle. It would be castration, dehorning, and to a certain extent, ear tagging, identification. Looking at the bill, when you get into the words intensive pain, suffering, castration, very intensely, short bursts can be painful. Painful itself, where's the line in pain with discomfort and pain? All species of animals, as in people, have different tolerances. There's also language in the bill, that words that are, as I believe said earlier, are subjective, prolonged and intensive. We'd simply say that the legislation is not necessary when ask you to find it inexpedient to legislate. And as always, thank you for your time and attention.
Thank you for your testimony. Any questions? Go ahead, Senator.
So just, thank you, Mr. Chair. Thank you for taking my question. Just for clarification.
Clarification, you said?
Clarification, right. So you brought up castration.
Mhm.
Are you, I have never castrated an animal, so just gonna put that out there. So, so genuinely, the only exposure I have to that is a pet, right? And our home, for which we went to the veterinarian, and there was pain relief and pain blockers involved. So is that not what's happening with larger animals? So, and are we trying to measure like how much tolerance an animal can tolerate, like take? I'm curious.
I don't know as we are. I don't believe so. As far as castration goes, if we want to talk about that, my personal experience
You brought it up. Yeah, you brought it up. So yeah, we're talking about it.
is banding the animals, which is a rubber band. It's placed usually a young male beef animal, and I mean, it's subjective. Where's the pain level? There's certainly discomfort for a short period of time. Is the bill says? Is it intensive? And again, it changes as the animal's age and the procedure used. I think yes, often when a veterinarian is used for that procedure, it's when they're older, and then they do require because there can be it could be painful as they age and it's done later. But again, it's just the way the language is worded. It raises questions for our membership.
Okay, so may I follow up?
Yes, you may.
So is the assertion from the Farm Bureau that the younger an animal is, the less pain, the more pain it can tolerate? I'm just trying to get how much pain does an animal have to experience, and when we're going to assert,
First of all, I did not say that the older an animal gets, the more. But I
just going with what you just said. So
I don't believe I said that, Senator. But if I did say it, I spoke inaccurately. And I guess restate your question for me, please.
Thank you. Quick question for you, just
Yes.
maybe I haven't followed along close enough. I'm looking at animal, household pet, wild animal. Should we be differentiating more? Does it differentiate somewhere that I didn't pick up as much between like a livestock animal and like we were talking pain threshold?
Where are you looking, Mr. Chair? Sorry.
Oh, I was in section 2. I saw animal means domestic animal, household pet, or wild animal in captivity. It just seems strange that they're all together to me.
Yeah, I don't have it in front of me.
Okay. I'm sorry. I'll look into it more in my own.
Okay. I
Thank
could
you.
certainly follow up with you.
Thank you and your testimony. Last but not least, I think Susan Adams Leclerc. Oh, okay. Okay, very good. I'll get to you next. Thank you.
Good afternoon.
Good afternoon, ma'am.
I own Our Town Kennels in Peterborough. as well as I represent Cold Springs Healing Foundation out of New Ipswich. I didn't anticipate speaking, but I come in support of my fellow breeders, vets, you know, folks that make a difference in the lives of others. When you create legislation on top of legislation, it opens up, I think, personal interpretations. Like you spoke about the cat being hit by a car. When you have a pet owner that just goes into an orbit state, you know, they're not rational, they're from an emotional place. And they become angry. And you can have laws be interpreted through, I think, emotions. And so as we define torture, I think common sense is relevant. Intentional, yeah, when somebody beats a dog to death, it's intentional. It's not a mistake. It's not an accident. Now, if somebody accidentally slipped and their dog fell, it's icy out right now, and a dog falls down a flight of steps, or a cat does, and they have severe pain, an owner doesn't have the money to take the pet to the vet, so they wait. Now they cause duress. Could it be interpreted as intentional? Yeah, maybe, if you have that emotional mindset. But if you think, well, the steps were slippery, a vet bill is expensive, to wait and see is a normal practice of a person that owns pets, dogs, cats. I'm a dog person, but I have a cat. And I think that when we look at legislation to be put before the people, remembering there's a lot of us that do this for passion, not for money. Cold Springs is a nonprofit as well, and they make a huge difference in the lives of others. And we're talking a lot of dogs. They get in dog fights, you know, and people say, well, why would you let them together? Who doesn't have 3 or 4 dogs that run together in a field or on your property? And things happen, and then these things can be exploited. And then it takes these dogs off the market to serve people in the capacity that they were bred for. So I ask that as you make decisions, understand the impact, and people on both sides are passionate about how they feel and making sure that animals are safe. But I've been in this gig for 30 years. Animal rights activists have good intentions, most of them, some of them bad intentions. So you have to weed through that and see how this bill affects people, and common sense really prevails. I'll take questions if you'd like.
Thank you.
Thank you.
And Joan O'Brien, who I'm sorry I missed earlier.
So I'm Joan O'Brien from Amherst, and I've just been tortured waiting for my name to be called this entire time. But now I get to respond to some of the things I heard. So I serve on the board of the New Hampshire Animal Rights League, but I'm here today just representing myself in support of Senate Bill 290. And I do have a suggested improvement for it. First of all, we've heard people question whether we need this definition, and I think we'll just get back to what Senator Waters said. Law enforcement asked for this. They asked for something that would help them to determine whether or not they could prove something was torture. So that is the origin, and it's needed. And the concerns raised by farmers and breeders, I think you might take away from that it implies that they worry that what they're doing, they're not convinced that what they're doing isn't causing pain and suffering. That's why they're here. So I told you I had a suggested improvement, and I think that including a specific act in the definition will aid law enforcement, and that would be drowning. We want to clarify that drowning is not euthanasia. There's legal precedent in which drowning has been wrongly presented as euthanasia, and euthanasia is a good death. It's quick, it's painless, and it puts a person or an animal out of their misery. So there's a case of Dewey the dog, I think it was 2005, where 2 young women drowned a dog that belonged to one of their boyfriends, and the defense argued that it was an act of euthanasia to end the dog's suffering. However, the prosecutors successfully argued that suffocating the dog with a sock, stuffing him in a bag, and then drowning him constituted torture. And the judge found probable cause to back that up. So there we have an example, drowning as torture. I believe that some legislation followed due to outcry from the public. They wanted drowning to be explicitly listed in law. And what I hear, because I wasn't around, is that it didn't pass because the farmer was worried that he wouldn't be able to euthanize piglets by drowning them in a trough. I would say that that's not euthanasia, as we just discussed. There's other ways for farmers to kill animals that are sick or dying, like blunt force, trauma is typically what I hear is standard agriculture practice. So we shouldn't even be, encouraging that. Anyone who has had to euthanize a beloved pet knows how painful that is. Can you imagine if your veterinarian proposed drowning as the method? Drowning is neither quick nor painless. By including it in the law, we can eliminate future ambiguity. Both state and federal laws already recognize drowning as a form of animal cruelty. So Angela Ferrari mentioned the PACT Act, which actually has the word torture in it. It's the Preventing Animal Cruelty and Torture Act, and it specifically lists drowning as one of the crimes. Massachusetts has a PAWS Act number 2 that explicitly prohibits drowning animals and calls it aggravated animal cruelty. It's a felony. Even in research settings, drowning animals is highly scrutinized. The USDA recently cited UNH for 2 violations for drowning 670 animals. In the inspector's report, she noted that drowning small mammals does not meet the definition of euthanasia, which requires a method that provides rapid unconsciousness and death without pain or distress. And there was no documented effort to search for alternatives as required. So for all these reasons, I urge the committee to support this bill and explicitly include drowning in the definition of torture, because tomorrow we could have another case of someone drowning someone and it'll be ambiguous again. And I also would suggest that you move up the effective date of this bill because it'll benefit all the stakeholders more quickly. Thank you.
Thank you for your testimony, ma'am. Any questions? Yes, ma'am. Do you wish to speak? You certainly may. Thank you, ma'am, for your testimony. If you can say your name.
Yes, good afternoon. Pardon me. Marla Fields. I signed in on the sheet. I'm here on behalf of myself. And I'd like to just follow up with what this lovely woman has discussed with regard to the drowning, et cetera. Those are clearly intentional acts. And I think within the definition, people are not arguing about what is known as intentional acts. I personally don't think that we need to have a definition of torture. I think that Black's Law Dictionary defines it, Webster's Dictionary defines it, and most jurors would be able to listen to testimony about drowning and understand that that's cruel behavior and it's wrong and it shouldn't be tolerated. What I think here is the the broadened definition of negligence being added. And I think that that's the difficult place, and that the definition as currently worded is too broad and can pull in too many things that could be misconstrued and cause difficulty for the citizens of New Hampshire. I'd also like to suggest or let you know that I'm a nominee for the Governor's Commission on Cruelty to Animals. And as just a nominee, I'm not able to vote. So at those discussions, many people at the committee were in favor of the definition as written, but not everybody. And I'll include that to be the chiefs of police, who is also a nominee as myself, who has indicated he can't support this definition because of the inclusion of negligence. So.
Thank you very much, ma'am. Any questions?
You're welcome.
Seeing none, thank you very much for your testimony.
Thank you.
Does anyone else wish to testify who hasn't had the opportunity, didn't sign in, anything like that? Seeing none, thank you. Welcome to Judiciary, Senator McHugh. You're introducing 261, I believe. I am. Good afternoon, Mr. Chairman. Thank you. Good afternoon, members of Judiciary. Thank you for your stamina today. I'll try to be as brief as possible. I'm Senator Tim McHugh, representing Senate District 11, including Merrimack, Amherst, Milford, and Wilton. Thank you for the opportunity to speak today. I'm here to introduce Senate Bill 261, which is relative to preserving evidence and seeking the truth in certain circumstances during custodial interrogation. So I'm here obviously to speak in support of recording these interrogations when subjects are in custody and not free to leave. Video cameras and audio surveillance are everywhere. We're on YouTube right now. Very seldom is there an expectation of privacy. Very seldom do we not have Alexa, Siri, or Rufus, yes, that is one too, or Google or some other device listening and actually recording our voice on a daily basis and our movements and our likenesses. So it just seems to me like it's a basic bit of common sense that when our very freedom is possibly threatened, that we ought to do the same thing to preserve that. Sure enough, there goes one of those devices just now. Sorry about that. Probably dozens of people at home are experiencing the same thing, and I apologize for setting off their devices with my testimony. I do believe that a clear, indisputable record of an interrogation protects everyone by ensuring that no detail is lost or misinterpreted, including the way a question is posed, the inflection, all of the things that lead up to a particular subject's answer. I think all of those bits and pieces are vital to the full record. And in many cases, this practice is already done. But in other cases, we rely on an incomplete set of paper notes that can lead to confusion, discrepancies, or unintentional creative editing of the events. Many other states, like Texas, have long championed electronic recording. Arizona had a similar good experience, and their law review studies have shown that recording interrogation not only preserves evidence, but also improves the techniques law enforcement uses during these high-pressure moments. Montana's statutory framework under their code has helped minimize miscommunications, ensuring that every single word spoken is captured. Indiana has a similar framework, and our neighboring states, Massachusetts, Vermont, Maine, and Connecticut, have also embraced this same practice. Now, don't get me wrong, many of our departments do this. I just think it should be standard practice. Our experience tells us that clear recordings streamline the pursuit of justice for the victims, for the accused, for law enforcement, for every step of the way. And being able to review the practice can help us pinpoint areas for improvement. And when we address all of those aspects, it could lead and should lead to fewer trials, quicker resolution, and more outcomes swiftly and efficiently. So I think since it's really not about second guessing our law enforcement colleagues, but it is about adopting a modern and simple approach to reinforce the transparency and accountability that we all seek for victims, law enforcement, and of course the accused as well. So having this factual record, we bolster trust on both sides of the process. It could be as simple as a department-issued cell phone that we have all come to know is quite secure. I think we've all read the accounts of how encrypted the various brands of phones are these days. It's truly a win-win situation. So if we just consider those practical benefits, I hope you'll consider this proposed legislation thoughtfully and come out with a positive recommendation. So I do urge you to support Senate Bill 261 and confident that in doing so, we will improve the judicial outcomes. And just like John 8:32 says, the truth shall set you free. Be happy to take any questions on the particulars of this legislation. There are a couple of experts behind me that will testify. I understand one of the departments that will weigh in has a couple of technical, a few words here and there that they would like to add on one or two of the paragraphs, and I do support those small changes that you'll hear about from the experts, but I'll be happy to take any questions if you have any. Thank you, Senator. Go ahead, Senator.
Thank you, Mr. Chair. Thank you, Senator McHugh, for taking my question. I have two, if the chairman will grant some latitude. They're unrelated. They're related to the same bill, but not to each other. First, on page 2, line 8, a parole violator not charged with a new offense. Do you mean in parole hearings or in the event that someone on parole was rearrested for something different?
Senator Altshuler, thank you very much for answering that or asking that particular question on that particular line. That actually is one of the very minor wording changes that the Department of Corrections would like to address. They would like to add a couple of words to those particular two lines. So if you don't mind, I'll let them speak to that particular language. I know for sure they would like to add the words after the word hearing on line 7, the words and investigation. I will let them speak to your specific query about new offense. If that's okay.
Thank you. And then if I may
Yes.
follow up. So also on page 2, and this is curiosity of process question, section 2, line 14, if an individual to be interrogated requests that the interrogation not be recorded, or if the individual being interrogated indicates they will not participate in further interrogation unless electronic recording ceases, then we let it go. Why wouldn't we just keep recording? If we can't ask people don't ask law enforcement officers to turn off their body-worn cameras.
Yeah.
So now we're in an interrogation situation, and my reading of this bill is that you want to just keep rolling right? Whether it's audio or video and audio. But there's an exception if somebody says, hold up, I'm not going to talk if we're recording it.
Senator Altshuler, I actually think that's a terrific question. Thank you for asking. I'm neither a law enforcement officer nor an attorney. So I might be completely wrong in the answer, but the subject, my understanding, would be Mirandized in this case, since they're in custody, and they would be free to exercise their right to not answer questions. Not sure entirely, perhaps one of my learned colleagues who are attorneys on this particular panel would care to weigh in on that, or one of the folks behind me would also care to weigh in on that particular option, that particular question.
Sure.
So I think an attorney would be better qualified to answer that particular question.
Yeah, I think that the question is my question is specifically, and anybody who's listening, but who's sitting behind you who wants to address this in their testimony, specifically line 15 is not that someone is invoking their constitutional Fifth Amendment not to incriminate themselves, but that they are making a stipulation that they will not participate in the interrogation. So there's an assumption that they would participate in the interrogation, except they're saying, unless you turn that audio video recorder off. So that's the piece where I don't understand how that request.
I think it's the same. I think they're refusing to answer any questions, which is their right to do. And that's how I interpret it.
Thank you, Senator. You're all set. Thank you.
Thank you, Mr. Chairman.
Thank you. My representative here. Please, please, please. Where's the rep? Oh. I don't know if he's testifying. He didn't sign in. I'll just go in order. Steve Endres. Jane, did you want to go? Okay, if you can wait. Okay, thank you.
Good afternoon, members of the committee. My name is Stephen Andrews. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years. Generally, we love recordings. As lawyers, you argue about the facts and you argue about the law. But if we have a recording, then we know what the facts are, and there's nothing to argue about in terms of facts. So we like recordings. In addition, there's really nothing more powerful than being able to play a confession to the trier of fact in the defendant's own words. Unfortunately, or fortunately, that doesn't happen very much because, frankly, when people confess on recordings, they tend to plead guilty to offenses. But the issue of recordings isn't new in New Hampshire. In 2001, there were cases before the Supreme Court regarding recording Miranda and recording confessions. That case was State versus Barnett, where the New Hampshire Supreme Court came out with the recording rule. And the New Hampshire Supreme Court essentially said, you don't have to record the administration of the Miranda warnings. You don't have to record that part. But you do have to, if you're going to record the confession, you have to record the complete confession. In 2004, that was revisited, and people essentially wanted to say, no, we have to record in every case. And what the New Hampshire Supreme Court said, and I think I think they said it so well, I just want to read you a quote from the case. The defendant's proposed rule, however, would amount in practical effect to a mandatory recording requirement for all police station interrogation. Much of the police work during non-consensual interviews involves judging a suspect's credibility and attempting to discern a consistent story. The police often do not know whether their questioning will lead to an inculpatory statement or even if they're talking to the actual person who committed the crime. Yet, under the defendant's proposed rule, the police would be obligated, even while unsure of whether they had the correct suspect, to record every minute of a police station interview because if it later turned out that they did have the correct person, they would otherwise be precluded from introducing any recorded custodial statement at trial. We declined to adopt such a rule. That's a quote from State versus Velez. It's a 2004 New Hampshire Supreme Court case. And while 2004 may seem like a few minutes ago, it was actually over 20 years ago at this point that they articulated that standard. And I think that those words ring true today. This bill also, I think the language within it is very confusing, and I think it's going to give people a false sense of what and what is not recorded. When you look at page 2, paragraph 1, custodial interrogation at a place of detention shall be recorded electronically. Recorded electronically is defined on the previous page as an audio or audio and video recording. So what the bill would mandate is an audio recording at a minimum of a custodial interrogation at a place of detention. Custodial interrogation is further defined on the page before as the same meaning as case law by the New Hampshire Supreme Court. So let me give you an example of what's not custodial interrogation in New Hampshire. If I'm a police officer and I'm investigating, say, a robbery case, and I know that my suspect is John Smith, and I hear that John Smith got picked up on a completely unrelated warrant and is currently sitting in the Merrimack County House of Corrections, I can go over and talk to John Smith. Even though he is in custody at the Merrimack County House of Corrections, as long as his freedom is not further restricted as I'm speaking with him, that's not considered custodial interrogation in the state of New Hampshire. That case is State versus Ford. It's a 1999 New Hampshire Supreme Court case. So not all interrogation at, say, a House of Corrections or prison would have to be recorded. The question would be whether it's custodial interrogation. The second part of that sentence on page 2, paragraph 1, is custodial interrogation at a place of detention. And place of detention is defined on the page before as a fixed location under the control of a law enforcement agency where individuals are questioned about alleged crimes. So unless I was at a place of detention, I would need to record the confession. So again, under New Hampshire case law, there's a case where the police are actually walking around a clearing chatting with someone about an aggravated felonious sexual assault. And despite the fact that they're outside walking around a clearing near this person's workplace, the Supreme Court said that was custodial interrogation. So while that person would be required to have Miranda warnings, under this bill, it wouldn't be required to be recorded because that's not a place of detention. Similarly, since a place of detention is a fixed location under the control of law enforcement, as I read it, various other locations, such as the back of a police cruiser, a school, a place where you work, none of those would be places of detention. So you'd only have to record custodial interrogation in places of detention. The second sentence of that paragraph starts at line 4, says a custodial interrogation at a jail, police, or sheriff's station, holding cell, or correctional or detention facility should also be recorded. Now, to me, that sentence makes no sense because place of detention includes the term a jail, police, or sheriff's station, holding cell, correctional, or detention facility. So that second sentence just repeats essentially what the first sentence says and should be eliminated. The third sentence says a custodial interrogation at any other place of detention shall be recorded by audio means at a minimum. But again, that sentence makes no sense because the first sentence only requires audio recording to begin with. And I understand that this bill is similar to one that was introduced last year and probably retains some of the same language as last year's bill. But essentially, it makes no sense as you read it currently. With reference to that paragraph 2 that we talked about, lines 14 to 20 on the second page, I agree. Why are we letting the defendants control whether or not they're being recorded? Certainly, I'm sure you'll hear from law enforcement behind me that they've interrogated suspects in the past who have said, I'm willing to talk to you, but I don't want it recorded. Because they want to get it off their chest, they want to do that type of thing, but they don't want to record it. Well, normally, if a person says, I don't want to be recorded, it's illegal to surreptitiously record that person. However, in New Hampshire, under the wiretap statute, there's an allowance for one-party recordings, meaning that in the investigation of certain crimes, if you have authorization from the Attorney General's office, you can in fact surreptitiously record people. So, for example, murder is one of those enumerated crimes where you can surreptitiously record people. So you may have a murder suspect who says, I'll talk to you, but I don't want to be recorded. Well, under our current law, the attorneys would be allowed to essentially grant themselves a one party if they authorized to do so through the Attorney General's office, and they could surreptitiously record that interview without letting the suspect know. However, if this bill were to pass, that would no longer be the case because you're allowing the interrogated person to control whether or not they're being recorded. Further down in the bill, page 2, paragraphs 3B and C from lines 25 to 32, talk about if both audio and video recording of a custodial interrogation is otherwise required by paragraph 1. But the difficulty is if you go back up to paragraph 1, video recording is never required. So those two paragraphs, B and C, suddenly make no sense in light of the fact that in paragraph 1, audio recording is all that's ever required. So I think that I'm opposed both to the concept of creating a statutory policy requiring all these things to be recorded, because I think that law enforcement needs to be flexible. But to the extent you were trying to create that policy, this bill does a horrible job of doing that. As we've talked about in the past, police utilize body-worn cameras, and those body-worn cameras are going to record everything. As I've testified to before to this committee, I think there's problems in the body-worn camera statute, and I would encourage you to examine that statute to try and accomplish this purpose rather than passing this bill. I'm happy to answer any questions.
Thank you very much for your testimony. Go ahead, Senator Upshaw.
Thank you very much. Thank you, Mr. Chair. Thank you for taking my question.
Thank you.
Can we go back to page 2, lines 14 through 17-ish?
Yes.
So would it be more clarifying to delineate that if an individual to be interrogated is a suspect, because we know that everyone interrogated is not necessarily a suspect, but could be a potential witness? You know, they were in the area where an alleged crime occurred, and then law enforcement, you know, calls these people into a place of, what are we calling it, detention? The place of detention to question them. They are not under investigation for a crime, but witness. Would making that clearer about who each person is in that law enforcement situation make this paragraph better? I know you don't like it at all, but
Right, that's the difficulty, is that I don't like it at all.
Okay.
And I guess maybe it should say the interrogation shall not be recorded unless otherwise allowed by law, which would allow law enforcement, again, to surreptitiously record if it was in conformity to the wiretap statute. If that makes sense.
Okay, may I follow it? So, in your opinion, as a prosecutor, do you believe that Section 2, if people who are being interrogated who are not suspects are aware that they are not able to opt out of recording, that they will then not participate willingly and have to, but then we got to push this all the way down to being subpoenaed versus,
Right.
is this,
You certainly could
the
potentially have a chilling effect on people
Okay.
If you didn't give them the option to not be recorded.
as witnesses?
Correct.
Potential witnesses. Thank you.
Thank you very much. Seeing no other questions, did you have one, Senator Abbott? I'm sorry.
Thank you, Mr. Chairman. Just clarification, if you're just a witness, Isn't that outside the definition of a custodial interrogation?
So the definition of custodial interrogation is a person who is in custody and is being asked questions. The question of whether or not you're in custody is whether or not you're under arrest or its formal equivalent. So I could see a situation where, for example, if you were a witness and you said, I'd be happy to talk to you at the police station, and I put you in my police cruiser and I drove you to the police station, there's case law that would support the argument that you're in custody at that point, even though you've willingly come to the police station with me.
Thank you.
Thank you.
All set. Thank you. Ms. Graham, you're a no. You and Stephen, come on up.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Jane Graham. I'm the Strategic Communications Administrator for the New Hampshire Department of Corrections. To my left is Steve O'Rourke. He is a hearings officer at the department, and he's here to answer questions that I might not be able to. So, the department, we're neutral on this bill. We don't have a problem with the bill itself. However, there are several areas in the bill that we would like to see some language changes, and we're respectfully asking for that if possible. The first one that we are looking at is on page 2, lines 7 and 8. It reads, the section shall not apply to an administrative disciplinary hearing in a state correctional facility or to a parole violator not charged with a new offense. We would like to see added administrative disciplinary investigation along with that. And then Senator Altshuler, I knew you had a question about that paragraph with the parole violator. So when it's talking about new charges there, this is an administrative disciplinary hearing within the prison. So it would be somebody that got a disciplinary ticket. We wouldn't be charging them with a new crime. They would already be incarcerated and convicted at that point for us, because we're overseeing prisons, not jails. Does that clear that up? Okay. Okay, you're welcome. Our next one on page 3, lines 1 and 2. It reads that paragraph 1 of this section shall not apply to a spontaneous statement, and I won't read the whole thing, but the department's asking to add after that paragraph, or a statement made in response to a question or direction associated with the routine management or operations of a correctional or detention facility during the booking, housing, or management of the individual. So just our routine every day when we book somebody, those routine processes, we would like to see that clarified there, that it doesn't apply. The department frequently obtains documented statements associated with criminal misconduct from our staff who are not sworn law enforcement. We have staff that are mental health clinicians, staff that work in the kitchen, nursing, functions like that. They're correctional line staff, but they're not law enforcement officers. The department respectfully recommends adding a third section after the following on page 3, lines 8 through 11, where it reads, the presumption of inadmissibility of statements provided in 594A4 may be overcome, and statements that were not electronically recorded may be admitted into evidence in a criminal or juvenile delinquency proceeding brought against the person if the court finds, and we would like this section added. The statements occurred at a correctional facility and disclosed the admission of a crime, the intent to commit a crime, an accomplice to a crime, and were documented by a certified member of law enforcement or correctional employee. We do have times where things like that happen, and it might be a staff member who is, again, a civilian staffer who does not have a body-worn camera. Those incidents are always documented within our walls, but they wouldn't be necessarily reported. And the last one that we wanted to add is page 2, lines 7 and 8, where we were talking about interactions between probation, parole officers, and parolees. It specifically talks about parolees, but it doesn't talk about probation. So those interactions between probation parole officers and either probationers or parolees, there's a certain level of trust that they try to build up with folks that they're supervising. And we were just, and while parole is pretty clearly spelled out there, probation's not. So we would ask that probation be added as well as parole. And I'm happy to take any questions, or if you have questions about disciplinary procedures or hearings, Steve's here to answer those as well. Thank you.
Seeing none. Thank you.
Thank you very much.
Chief Sullivan.
Would you mind giving your notes that, all those to the, yeah, thank you.
Thank you both. Afternoon, Chief.
Senator Gannon, Chairman of members of the committee. My name is Patrick Sullivan. I'm here to testify on behalf of the New Hampshire Association of Chiefs of Police in opposition to Senate Bill 261. I am the Executive Director of the New Hampshire Chiefs of Police and a retired Chief of the Goffstown Police Department. There are ample constitutional protections in place regarding custodial interrogations. I think you'll find that law enforcement across the state follows process and procedures for interview and interrogation and do an outstanding job according to the law. To say that an admission of guilt to an officer while in police department would be discounted because it is not audio and or video recorded would make our jobs more complicated and at times not feasible. Most police departments are already audio and video recording interviews and interrogations, but not all police agencies are capable of doing that because of the cost of the equipment. While establishing a fund in place concurrent with the passage of this bill will likely result in numerous inadmissible confessions while awaiting the adequate funding for equipment and its proper installation. Currently, there are 244 police departments in the state of New Hampshire. That's a big ask. The vagueness of the language within the proposed bill is also a concern. By codifying custodial interrogation shall have the, quote, same meaning as established in case law by the New Hampshire Supreme Court. Certainly, there may be different standards both under New Hampshire State Supreme Court and the U.S. Supreme Court rulings, which would make it difficult to follow either case law should a new ruling come out of either court. Even if agencies have recording capabilities, the audio and visual devices may not be where the subject is willing to speak with us. Officers have conducted numerous interviews outside the standard interview room, such as in a Sally Port, booking room area, police station lobby, personnel office outside the police department. The majority of police departments that have in-house recording capabilities only have recording capabilities in the interview rooms. Much like an independent digital audio recording device, the file from the interview rooms must be taken in from the network's recorder's hard drive and transferred to the department's server. Not all the officers have access to a detective's division or office that needs to be locked when not occupied due to sensitive case files stored in there. Finally, this bill says there is an option for audio or videotape interrogation during interrogation, yet throughout the body of the bill, it indicates a desire for a videotape, especially when it comes to funding. This is a slippery slope to require one or both or all. In closing, we ask that you find this expedient to legislate. I would also like to speak to the question concerning when a person would not want to be recorded. I served 2 years undercover, and interviewing a person that has been arrested for drugs and wants to, quote unquote, become a confidential informant, they may go, I'll tell you everything you want to know, but I'm not talking in front of that. I'm not talking into a tape recorder. It happens frequently. Do we just turn a blind eye and walk away from this information the person's willing to give to us? I think that's reckless on our part to do that. And I'd welcome any questions.
Nope. Okay.
Thank you.
Bill Bright.
Good afternoon, Chairman and members of the committee. My name is Bill Bright. I am a New Hampshire State Trooper. I'm a major with the State Police. I oversee our Investigative Services Bureau. My background is in the Major Crime Unit. I spent 10 years in investigating homicides with the Major Crime Unit. And since then, I spent some time in our drug unit, overseeing the drug unit, as well as the last several years supervising all of our detectives within the division. Many of the points that have been brought up were points that I was thinking of as well, so I won't continue with that. But the biggest point that I would like to just point out with this bill is that circumstances are always different in our investigations, and they can't be predicted. So whatever scenarios we are trying to think of, I can guarantee you that there's going to be another scenario where there will be a situation where it will be extremely difficult or unable to record somebody who is in custody that wants to confess to a crime in a certain location. Like I say, I can't predict what that will be, but I can promise you that that is going to happen. And the question to the committee is, are we going to then disallow that information that may be extremely important to a death investigation, a serious assault, a sexual assault, a robbery, whatever that case may be. So that's my main concern with this, is that the circumstances are unpredictable. I have had situations where I've been interviewing somebody on a recording, non-custodial though, where they have said, I'll continue to talk to you, but I want that recorder shut off. So that happens frequently. In this bill, there's some of the, as was expressed, it is confusing to read through and try and think of where it is taking you with all the different links back to paragraphs and things like that. I'll go beyond some of the things that have already been talked about and talk about the maintenance of the language about the maintenance of recording equipment is very vague. If you go to the end of page 2, starting at line 21, the paragraphs following, they each talk about recording equipment failing despite reasonable maintenance of the equipment. What is reasonable maintenance of recording equipment? That's not very clear as far as I'm concerned. And then beyond that, the grant monies that are allocated in this bill, I believe even if we were to try and establish this law, the $50,000 to get recording equipment for every police department in the state is severely underfunded. I know it's easy to say, well, we could do that with a department issued cell phone, or whatever those means may be. But the reality is that in criminal cases, I mean, that evidence is extremely important. So we have to think about retention of that evidence, the security of that evidence, and how we handle that evidence all the time. So just having a recorded confession to a murder on a department cell phone, where as was pointed out, I mean, those cell phones are listening to us all the time, and I don't want that evidence to go to the wrong place or whatever. So it's important to do these things the right way. And in order to do it the right way, just to outfit an interview room in a police department, we have a quote. If you look at the end of this proposed bill in the fiscal statement, for $18,000 per room, approximately, to outfit with recording equipment and proper storage of that evidence. If you were outfitting an interview room in a police department. So I think that there are several issues with this bill, the way it's proposed, and we are opposing it.
Thank you, Major. Any questions? Seeing that, thank you very much for your testimony. Thank you. Cynthia, I think it's Musso. Get my little red buttons.
Is that right? Okay, awesome. Thank you so much to the committee. My name is Winnie Yee. I'm a state policy advocate at the Innocence Project. We are a nonprofit organization that works across the country to exonerate the innocent and support policies that help prevent, reveal, and address wrongful convictions. And today, alongside the New England Innocence Project, we're expressing support for Senate Bill 261. This bill is really about strengthening the integrity of our criminal legal system by promoting the recording of custodial interrogations. And I just want to note that a version of this bill was first introduced a few years ago in 2022. So it's been revised over the years with feedback from different stakeholders, and we've appreciated the opportunity to engage with them, including folks at the New Hampshire State Law Enforcement Accreditation Commission. You know, this bill is really about trying to be solutions oriented. It's not trying to make the lives of law enforcement difficult. In fact, it actually benefits them as well. And we want to make sure that there's a fair administration of justice. Just to get to one of the examples that was raised, you know, if the person being interrogated requests that the recording is turned off, that does not mean that that entire interrogation would then be inadmissible. In this bill, we have been solutions oriented in trying to put in provisions that would still allow that to be admissible, and simply the law enforcement officer would have to document that request was made, and they can still overcome some of those burdens, and that could still be admitted. So I just wanted to name that. So just to get into my remarks, for decades, the law enforcement and legal community have long recognized how recording custodial interrogations helps prevent wrongful convictions, promotes safer communities, and improves transparency and accuracy. The International Association of Chiefs of Police, the National District Attorneys Association, and the American Psychological Association have all issued model policies in support of this, going back as early as 2004. And the APA recently issued another entry in 2025, further corroborating the evidence on this. And today, 30 states, the federal government, and a number of law enforcement agencies, including in New Hampshire, all record interrogations. Recording creates a record of what occurred during an interrogation. So for the innocent, it can help prevent the tragedy of a wrongful conviction. We know that since 1989, there have been over 3,600 known exonerations, and in a third of those wrongful convictions overturned by DNA, false confessions was a contributing factor. Recording ensures that an individual's rights are protected during the interrogation, and it serves as a deterrent against coercive techniques that can cause false confessions. It also alerts investigators and courts to whether an individual has different vulnerabilities or mental limitations that can make them more susceptible to falsely confessing. At the same time, recording benefits law enforcement. It would protect law enforcement against false claims of misconduct because it's on the record, it's on tape, and it would help verify authentic confessions. It also allows the state and defendants to better prepare for trial, which can take place months or years later. Finally, recording of interrogations also benefits victims and survivors of crime. A wrongful conviction means that our criminal legal system has not only failed the innocent, but it has failed victims and survivors who are left waiting for justice while the actual perpetrator gets away. Recordings aid law enforcement because it can help capture intricate details that would have been lost if not recorded and aid in the investigation. And so for all of these reasons, we really encourage this bill because recording custodial interrogations should be the uniform standard. It shouldn't be that it just so happens one police station in this county records sometimes, but another county doesn't record. Your rights should not depend on what county you live in, but it should be consistent across the board. And so we urge you to support this bill. And I'd also like to note that it does provide funding to support law enforcement agencies because, again, we don't want this to be a burden on them. We want to support them through the implementation, something that so many states have already done, and we hope that New Hampshire can do next. Thank you.
I'm Cynthia Musso. I am New England Innocence Project staff attorney. I am the only person doing full-time post-conviction innocence work in New Hampshire. And prior to my work at the Innocence Project, I was a public defender for a number of years. It is rare that I would come in here and say to you that this bill is actually not very pro-public defender, but this bill isn't. So the practical reality is all of the points that the committee has made today about how there's a number, and a number of the testimonies have made today about how there's a number of scenarios where under the terms of the new bill, there would not be a recording is correct. That's correct. We intentionally made this a very limited circumstance where only custodial interrogations that are conducted in this place of detention would be recorded on purpose, so that we would not overburden law enforcement with scenarios such as, I'm out on the street and I meet someone, I just want to ask questions. We would not expect that that interaction to be recorded, nor would it be required by the terms of this statute. This is a very narrow bill. If I was a public defender, I would ask for a much broader bill. As an innocence attorney, what we're concerned with is these circumstances where we're eliciting false confessions in a direct way under custodial interrogation in these places of detention. We've also accounted for this different circumstances that keep being testified to and talked about by accommodating this in 594A5, which is on page 3, lines 8 through 14. There's a way to overcome the presumption of inadmissibility. All you must do is say, these weren't recorded, these are otherwise admissible, and here's why we didn't record them. And that they just need to provide a reasonable justification why they didn't record. And then you can still use the statement in court. It's not, we're not saying it's never admissible. We're saying it's not admissible unless you don't have a good reason for doing it. And one of those good reasons, Senator Altshuler, you talked about, why would we not let somebody agree to record? And that does happen even now. People say during custodial interrogations that are partially recorded, I'll turn it off, as the state police testified to, as the officer, former Chief Sullivan testified to, and they can be turned off. And if they can still use the testimony, any recording that, any statement that comes after that under the terms of the bill, they could still admit that at trial under that section that I just pointed out, under that exception. So that would still be admissible. Yes, it wouldn't be recorded because under the terms of the statute, that's true, but it still could be usable in court under the presumption section that we just talked about, which is A5. As Senator Abbas pointed out, any of these interactions with folks that are not suspects would not be considered custodial interrogation. As Attorney Endress admitted, custodial implies arrest or its functional equivalent. A conversation with somebody that's a witness and not a suspect would not be considered custodial interrogation. That would be an interview, that would be considered something else, would not be custodial interrogation. Custodial interrogation has a legal definition that criminal defense lawyers, criminal prosecutors are well aware of, and those interactions would not be included in that. In terms of the funding, as everyone has also testified to today, most of the police departments that we have in the state have already done this. In the time when this bill was filed and now, the Innocence Project did a survey of the police departments. We did not get answers from every single police department, but it's true that most departments already have the capabilities and abilities to do that. I don't know that we even have one answer that says there is nowhere that can do that. And again, everybody has these police issued cell phones. So you can, at a minimum, record in a scenario with your cell phone. This bill is very specific about the place of detention being a part of this. So it's not just a custodial interrogation that happens on the side of the street. It's all custodial interrogations that happen in these places. So the intention is to have a custodial interrogation where you're bringing somebody back to the police department. It's just not the case that most police departments in the state don't have that ability already right now. They don't all, that most of them have audio and visual capabilities at this time. So the funding that we put in here should accommodate that. Even if that $18,000 limit number is correct, and I have no way of knowing that, it would not be that all the police departments in this state need this, because they already have those already. Attorney Endress pointed out there's a lot of scenarios where police would need to judge credibility and make these determinations about these recording bills. Having this recording gives the jury the ability to make these credibility calls about a witness, about a suspect, about all of those things, and they can see those things in person. It's protective for both parties. So we did have this bill and we filed it before. I apologize because it does appear that we had a conversation with the Department of Corrections and we did intend to make those changes, and we will fix the pieces that were raised. We have no problems with those pieces. I don't think that the issues that the department has raised would amount to custodial interrogation. So for example, if somebody that was incarcerated told a staff member, hey, I committed this crime, That's not custodial interrogation. There's no interrogation, right? The person was not questioning them about a crime. It's just something that they spontaneously admitted, as would be anything that was said in a police cruiser, hey, this is what I did, or this is what happened. Those are the sort of things that don't fall under this bill. Those would still be admissible in court. But we have no problem adding that explicitly. I don't have any issue with that. I was under the impression that those had been incorporated, and I apologize that they were not incorporated. We also, as I said, did the survey of departments, and we also were able to meet with the Law Enforcement Accreditation Committee. We discussed the bill with them. Nobody raised any concerns. Nobody raised any issues with us. So we had no idea that there was any other sort of concerns raised at this time, but we did meet and discuss this bill with them. I'm surprised that anybody would object to this bill, as it's pretty narrow, and it's already just sort of codifying something that's already being done for the protection of all parties involved in the criminal legal system. I practiced in Manchester for a long time. We probably encountered more interrogations there than anywhere else. It's the largest county. And the practical reality is most of those confessions were all recorded. I don't think I ever recall having an interrogation that wasn't recorded. There are far less motions to suppress. There's far less litigation. There's far less ability to challenge any of these statements when they're recorded. It just reduces court costs by recording. It reduces frivolous filing of motions. And it, as everybody has pointed out, supports both the police and innocent parties. We've learned a lot from innocence cases over the years. There are cases where false confessions happen. Since 1989, there's been 453 exonerations that involved a false confession. That, as Winnie pointed out, the statistics suggest that that's almost a third of the DNA exonerations. There was a false confession. Essentially, 1 out of 3 folks that have been exonerated by DNA almost have admitted to a crime they did not commit. So it does happen. The only way we are able to ferret these out is by having these recordings. It's virtually impossible to recreate a record that doesn't exist between 2 parties who have different recollections of the same event. It's often said that there's Party A's version, Party B's version, and the truth. This is the truth. The truth is the tape itself, and that's why it makes the most sense for us to have these in these scenarios. It's hard to understand why folks would falsely confess. There are lots of reasons, but all of these, the recording can really highlight all of those and make it a lot easier for us to make these determinations. I don't want to belabor any of these points. I'm happy to take any questions. I will point out that we haven't had any exonerations in New Hampshire based on false confessions. We'd like to believe that's because New Hampshire is a flawless legal system, but it's just simply not supported by the national evidence that we've heard today. It seems that we are allowing some wrongful convictions to fall through the cracks. And I think recording police interrogations can help us ensure that we're getting the best, most reliable, honest evidence that's as accurate as possible. We should really always promote transparency and the best and most accurate evidence in our courtrooms, and recording this interrogation brings reliability to the criminal legal process and could prevent these wrongful convictions in the future. So we would encourage you to support this bill.
Thank you very much. Go ahead, Senator Evans.
Thank you, Mr. Chairman, and thank you for taking my question. I believe you testified that the majority of police departments are doing this in some capacity. If that's the case, then what's the need for having all these kind of, I would say, strict guidelines on it thereafter? It seems that there may be more unintended consequences than perhaps it was intended by filing the bill. But if they're doing it already, what change are we making here?
So the practical reality is most of them are doing it. We don't know about every single police department that exists. We only know that most are doing it. When we codify this, we shed light on the moments when they're not. And so the important thing is that we're able to catch those and that we're able to help those folks in that scenario.
I would just add that this would ensure that there's, it's a uniform policy and that it's consistent, because some, agencies might say that they do record, but maybe they're not really consistent with that policy. Maybe they only are recording if it's a case of murder. Maybe they're only recording, if one officer is doing that interrogation. So this would really ensure that there's consistency and that everyone is doing it across the board.
Well, what I'm saying is, if this is being done throughout the majority of the state, but you have the exclusionary rule section, you have the funding section, you have times when you have to, whether it's involving the Miranda, the waiver of the Miranda, all these other provisions in there. If it's just as simple as we're trying to get everyone to start recording, couldn't this be maybe a one paragraph piece of legislation that requires the recording? So I feel that some of the issues that are being brought up is, whether it's the application of what is it and is not a custodial interrogation, what was it waived? Is this going to be admissible? And I think, yeah, you may lose some cases on the front end, but back end now, if you have exclusionary arguments on this.
I think we were trying to encapsulate a lot of the concerns that have been raised today. And so the legislation has gotten to this point where we have, made exceptions or made what we consider reasonable deviations from this rule to accommodate a lot of the concerns that have been raised by law enforcement, that have been raised by different community folks and organizations. And so this is the way that the bill is. I certainly have no issue with a bill that says you should just record all interrogations, but we're trying to be reasonable and we're trying to implement this in a reasonable way. And we're trying to make sure that we aren't making things more difficult for law enforcement than it needs to be, nor are we including things that, such as the Department of corrections that, they've made, that we're not that we're not trying to be overbearing.
Thank you.
Go ahead, Senator.
Thank you, Mr. Chairman. Attorney Musso, you made a statement that of the DNA exonerated defendants, 1 in 3 had confessed. 1 in 3 of those had confessed, and I agree that not ever having been in that situation, it seems odd. Are you assuming that if those were recorded, that they wouldn't have falsely confessed?
So what we're pointing out there is more that those are the ones that we're able to collect. That's actually the ones we've been able to document. So in these false confession scenarios, I think the fact that there's 1 out of 3 is such a striking statistic. And these are the ones that we're able to document. Otherwise, if we couldn't document that, we wouldn't even have that number. So we wouldn't even know that amount. These are likely the recorded confessions that we're collecting. So the practical reality is that's already a staggering amount. I think the reality is we're probably missing more on the other end from not recording, rather than that this is a number that reflects the maximum height. I think this sort of this captures the bottom level.
Thank you. The point I'm trying to get at is, do you think somebody who's falsely confessing would not do it if they were being recorded? Do you think that there's a different thought process going on with that person?
Yeah, so recordings would definitely help because they can be, admitted and judges and juries can review that. False confessions happen for a number of reasons. I know we might be thinking like, I would never falsely confess to something I didn't do, but there are a number of factors at play. So number one is that law enforcement can use deceptive practices. They can lie to you. They can say, someone else said they saw you did it. They can sort of do that. There can be perceived intimidation. There can also be threats of harsher punishment if you don't confess. And also interrogations can go on for a really long time. So there are also, compromised reasoning ability if someone is hungry, if they've been sleep deprived. An innocent person really thinks, this is what they're after. They've been after me for 16 hours telling me that I did it. Maybe I'll just say that I did it to put an end to this because I don't want to be questioned in this room anymore. And I'll have a chance later to clear that up because I can get, a fair trial. But ultimately, we find that snowballs. And so there isn't later an opportunity to present that innocence.
I think the other factor is it's less about the impact on the person that's being interrogated and more on the ability of the court to assess that in the first instance. So in a pretrial context, the question is less about will this impact somebody to not confess, rather than will the court in the first instance before they get convicted be able to recognize this as a false confession before they get convicted. So the prevention piece is more about, can the trial court make that assessment before it moves beyond that and snowballs out of control. Thank you. Red light on.
Okay. Yes, my name is Jim Trainum. I'm retired from the Washington, D.C. Police Department, where I spent 27 years as a detective, over half of that as a homicide detective. For the past 20 years, since my retirement in 2010, even before my retirement in 2010, I worked with law enforcement agencies, prosecutors, judges, and others, both here and abroad, to improve interrogation practices. I've testified numerous times in courts across the country on interrogation practices and the evaluation of confession evidence. I've authored several papers on the topic, as well as a book on the subject itself. I learned about false confessions firsthand. As a new homicide detective back in 1994, I obtained what we later found out was a false confession. It was a very high-profile case. Our suspect was a 19-year-old young woman, well, being redundant there, a woman who we believed, based on what we thought was solid forensic evidence at the time, had participated in this kidnapping and murder. At that time, we did not record interrogations in their entirety. All we did was we would record the final version of the confession itself. So when she gave her confession, it was actually full of all those details that, as we love to say, only the true killer would have known. It was very convincing. It flowed. I mean, she sounded like a cold-blooded killer based on that final tape that we had right there. But during our follow-up investigation, and I meant to say that usually in these cases, what happens is the investigation ends at that point. You got the confession. And in fact, with this woman, her attorney believed in the confession and wanted her to go on and take a guilty plea. However, we had a couple of loose ends. So what we had to do was a little follow-up investigation. And during that time, we uncovered her alibi. And it was unshakable. And then we had to go back and reevaluate what our original evidence was in the case. And it turns out that it wasn't as solid as we thought. In fact, it was pretty much full of holes. We had to admit that she had nothing to do with the murder and that she had falsely confessed. So as a new detective, I wanted to know two things. What did I do in that interrogation room that convinced that woman that it was a good idea to confess to a crime that she didn't commit? And two, how did she know all of those details about the crime that were not public? Now, luckily, in this case, what had happened was she had made some admissions early on. And so we got a recording of those earlier admissions, and we accidentally let the tape run. And what we were able to do was go back and look at that tape and evaluate. And what we saw was that we were so convinced of her guilt based on what we thought was good evidence, that confirmation bias kicked in. And we missed evidence of her innocence, and we inadvertently, over time, fed her details about the case, sometimes in very subtle ways, that she was able to collect, and with our help a little bit, to be honest, she was able to create a believable confession. If we did not have that tape, we would never have been able to definitively said that that was a false confession that had been created by us. So naturally, I'm a supporter of videotaping interrogations in their entirety. And what we found around the country, as I've testified about this issue in other jurisdictions as well, is that when agencies began doing this, their detectives quickly become converts as well. My old agency, just as an example, our city council mandated that we come up with a policy to videotape interrogations. When we dallied, they said, we're going to come up with a policy. And we resisted, fought them tooth and nail. And, but now, in fact, within a year after that legislation passed, detectives were videotaping far outside the requirements of what the law said. Witnesses, victims, anybody, non-custodial interrogations, everybody, because they realized what an advantage it was. In fact, my own commander was quoted back then as saying that that law was the best thing that had ever been rammed down our throats. Now, we've talked about the value of videotaping. We all know that there's a reason that we document crime scenes with video and photographs. And we naturally place more reliance on evidence that is generated through surveillance videos that capture the crime or police body camera rather than independent witnesses themselves. It's called best evidence. It's called, being able to evaluate the evidence in its entirety. Confession evidence needs to be treated like every other evidence. With videotaping, you're not only evaluating the confession itself, you're also evaluating how that confession was created. And were the tactics proper, or was there some other thing going on at the time? Now, and at first, when I first got into this, the reason that they were promoting videotaping was because they were trying to identify wrongful, false confessions. And the thing about it is that, I'm sorry. Okay. But more and more recently, what I found is that this move has been used more to prevent unjust acquittals and all that, because once you have that tape, it's very hard, and it's a good confession and it's a good interrogation, it's very hard to fight it. And if the interrogation is not videotaped, you can be assured that that case is going to come under a severe attack in the court. And there's always a chance that even the best detective, even the most conscientious detective, is going to have a bad day on the stand. And you could very well lose that, what could have been a good confession right there. Now, I know that several agencies in the state already videotape. You need this law because it needs to be consistent across the board. There's a reason why those other agencies haven't started videotaping. And, this will help bring them on board. And it's because it's actually, the best evidence that you can get out there. And like I said, it also prevents another avenue attack against the confession at trial. A good defense attorney will point out to the jury, well, why aren't you videotaping when the state police are? Isn't this a good policy for you all? Now, over the years, I really have heard of every objection to mandating let's say videotaping or recording, in this case, of interrogations that you can imagine. Many are logistical issues, but there's a multitude across the countries. There's a multitude of agencies across the country that have overcome every single one of these objections and issues. And I'm sure that they would be more than happy to help any agency here navigate that as well. Now, however, I'm sad to say that I've actually heard some. I did a bunch of notes, but I can definitely write them up. Okay. I have heard some objections that actually emphasize the reason why we should be videotaping. And they actually came from two highly placed law enforcement officials with the Florida Department of Law Enforcement and the FBI. The first objection was that if the interrogation was recorded, then the agents could not control what parts of the suspect's statements were heard by the jury, thus muddying the waters. And the second objection was that the fear of the recordings would make the agents look bad in front of the jury. That's the quiet part being said out loud. That's the red flag. This bill is a good thing, and I strongly recommend that it be passed. And I'm sorry if I got a little verbose.
Thank you for your testimony. Do we have any questions? Seeing none, thank you very much. Does anyone else wish to testify who didn't get a chance to? Seeing none, thank you. Yep. Senator Fenton, head down to the hot seat. How you doing today, sir?
I'm good. You guys are busy, it looks like.
It's been busy enough.
Well, I won't take up too much of your time.
Oh, no, you might. We'll keep you here a long time.
You can do that too. Kate, do you have amendments to this?
Yeah. Senator Fenton, whenever you're ready, you go ahead.
I am always ready. Thank you, Mr. Chair. I don't often visit this committee, so it's a pleasure being here. I can see the work you guys are putting in and the hours you're putting in as well, so it's much appreciated. For the record, I am Senator Donovan Fenton. I represent District 10, and I'm here to introduce Senate Bill 139, which strengthens our state's civil rights protections by allowing individuals to bring private actions when their rights have been unlawfully interfered with or threatened. Under current law, only the New Hampshire Attorney General's office can initiate civil rights enforcement actions. However, we have seen a staggering 425% increase in civil rights complaints since 2017, and it is clear that our existing system is not equipped to handle the growing number of incidents alone. This bill ensures that the individuals who have experienced discrimination, harassment, or other civil rights violations have a legal avenue to seek justice on their own rather than relying solely on state intervention. Reports of hate-motivated incidents have been increasing across New Hampshire, with concerning activities such as divisive messages displayed over highways, vandalism of targeting places of worship, and disruptions at public meetings. These incidents are deeply troubling and do not reflect New Hampshire's values. It is important that we take meaningful steps to support those affected and uphold their rights and dignity of all residents. This legislation does not replace the Attorney General's role in enforcing civil rights protections. It strengthens it. I can't stress that enough, that it strengthens the Attorney General's role in this. And this bill assures that the Attorney General's office remains informed of all private actions filed and gives them the right to intervene in cases that affect the broader public interest. This dual approach allows for greater enforcement of our civil rights laws while easing the burden on state resources. New Hampshire took a stand against hate and discrimination when it first enacted the statute, and today we have an opportunity to build on that commitment by passing SB 139. We give individuals the ability to defend their rights, hold violators accountable, and ensure that our state remains a place where all people are treated with dignity and respect. Thank you for your time and consideration. I'm happy to take any questions you may have.
Thank you, Senator. Go ahead, Senator.
Thank you, Mr. Chair. Thank you, Senator Fenton. I see we have an amendment here.
Yes.
Would you like to speak to that?
So I kind of mentioned it in my overall testimony. This is an amendment requested by the Attorney General's office. It essentially just makes sure that any actions are made, the Attorney General is alerted of any actions made.
You just spoke really quickly. So
I speak fast, I apologize.
I was trying to take notes.
Pete, you get it all? See, Pete was ready. Did that answer your question, Senator? I apologize. I can slow it
May I
down.
follow up?
Yes.
Yes, thank you. So just so I'm clear, and we go back through what you just testified to.
Yes.
This does not supplant the Attorney General's role, but enhances the Attorney General's role.
Senator, thank you for the question. I think that's a very good way of putting it in a question. Yes, it would. I believe this would strengthen the Attorney General's role in situations like this. And I think I almost would call it a housekeeping bill in terms of that.
Last question, Mr. Chair. Thank you. And did you, was your testimony just that since 2017, civil rights violation complaints have increased 425%?
That is correct.
Thank you.
Seeing no other questions, thank you, Senator.
Thank you, Mr. Chairman.
Rep. Jonah, come on down. Sorry to keep you. You've been wandering in and out. We're slow today.
No, that's the set.
Oh,
But thorough.
does she need to go first?
No, there was a lawyer here from Peterborough who wanted to go first, but if it's okay with you, I just got to dash back to committee.
Okay.
But he's a constituent of mine. He's my boss. So if he wants to go first, he gets to go first. Thank you very much, Mr. Chairman, members and friends on the Senate Judiciary Committee. Love being in this committee room, just a very beautiful room. So if I had to wait in a committee room for 2 hours for the bill, this is the one to do it in. I think Senator Fenton handled this quite well. This just creates the private right of action for an individual who's going through a civil rights case to move forward with their civil rights case and have it be such that they don't have to go to the Attorney General to have that handled. This is something that's increasing in our state in a very rapid way, as we saw over 100% of people getting these increased, 425% of them. I mean, that's a pretty big increase. This legislation is mirrored, frankly, with all due respect to Senator Fenton, it was copied by Representative Gothright, and we'll be dealing with this legislation, the House version of it, in a House committee tomorrow. So I would hope at the very least the committee would retain this legislation in an effort to keep the vehicle just to see what happens in the House. But with that, Mr. Chairman, I don't have much else to add. I think Senator Fenton added it well, and you folks have, Senator Reardon, congratulations, by the way, on
your appointment to this committee and your appointment to the Senate. Looking forward to seeing what you do here. But that's it. That's all. You guys have had a long day, and I have to get back to committee. So
We're all set.
thank you very
On
much,
your
Chairman.
committee. Are you Representative Gothright? Behind. That's you, ma'am, right? Are you Representative Gothright?
Yeah.
Oh, okay. Okay. I saw you supported. I figured you forgot to check off speaking. Okay. That's okay. Give me 1 second then. Michael Atkins. Good afternoon. How you doing today?
Good afternoon, Mr. Chairman, members of the committee. My name is Michael Atkins. I'm an attorney at Shaheen and Gordon at our Peterborough, New Hampshire office. And in a volunteer capacity, I serve as the legal redress chair for the Greater Nashua NAACP. As folks may know, the NAACP is the oldest civil rights organization in the United States, having been formed in 1909. And it's important that people know that the NAACP is a nonpartisan and multiracial organization with a simple mission, and that includes to protect the civil rights of all people. I'm here on behalf of the NAACP and the 3 branches and the 1 college chapter at Dartmouth. The 3 branches we have are in Nashua, Manchester, and the Seacoast. And as Senator Fenton did a very good job of explaining, the purpose of SB 139 is simply to add a private cause of action for people who have become victims of the unlawful conduct already prescribed in RSA 354B. The only thing I would add in regard to correction, and I think I may have miscommunicated, but it's 465% increase in civil rights complaints. That's a report from the New Hampshire Attorney General's office, increase since 2017. And this is not isolated. This is going on in Nashua, in Manchester, in the Seacoast, in the Monadnock region, and the Lakes region. As this committee may know, as a result of this, the Attorney General's office expanded their civil rights unit threefold or fourfold in November of 23 from 1 person to 4. This simply would allow any citizen in New Hampshire whose conduct of folks violates RSA 354B to be able to go to the court and not have to have the Attorney General be the only person that could seek redress. I think we'd all be in favor of people being able to seek redress for the conduct that is prohibited by statute. As indicated, the Attorney General would continue to be involved, both notified of the court filings, the amendment to which I think is a good idea, giving them the right to intervene to further protect the public interest if they would like. And the last thing I'd like this committee to know that our surrounding New England states with similar legislation all provide private causes of action. New Hampshire does not. Vermont, Maine, Massachusetts all provide private causes of action. So I sincerely appreciate the time and consideration, and I'll take any questions the committee may have.
Just a quick question that's not really important or anything on this bill, but the 465% increase, is it in certain areas? Has it been anti-Semitic because of the Israeli conflict? Is it certain areas or is it broad?
It's broad, and it is included anti-Semitic with swastikas being painted on a synagogue in Portsmouth, painted on the state building in Laconia, in Monadnock region, school kids telling Jewish classmates that they were looking for Hitler to come back so that they could go to the gas chambers. In Nashua, Manchester, and Seacoast, racial incidents that included just some of the most abhorrent conduct that I've ever seen as a member of the bar in over 35 years.
Thank you. Yes, go ahead, Senator.
Thank you, Mr. Chairman. Thank you for taking my question, and this is about the remedies that are in the
Yes.
statute. So I would assume a private right of action would include the same remedies here, but Roman numeral 4 in the here says, nothing in this section shall limit the right of the person damaged by the violation to pursue any other appropriate cause of action. Would us giving a private right of action mean that they would have to bring their entire suit, any cause of action they had? Or would Roman numeral 4 still exist where?
Roman numeral 4 would still exist. So if someone commenced, a private citizen commenced an action under the proposed amendment, they would still retain all the other rights. Same way, instead of making the complaint to the Attorney General, and again, that's just recorded complaints. I want this committee to think about the number of people that aren't picking up the phone and calling the Attorney General, but they know Attorney Smith and Attorney Jones or anyone in their community who could help them. But that right would still exist, not altered at all.
Thank you.
Seeing no other questions, thank you very much.
Thank you very much.
Does anyone else wish to testify? I'm sorry, go ahead. Come on up.
I waited all this time. You can't forget me. Good.
That's probably why I forgot you. It's been a long time.
Good afternoon, Chair Gannon and members of the Senate Judiciary Committee. I am Senior Assistant Attorney General Sean Locke, and I'm here on behalf of the New Hampshire Department of Justice. The department doesn't take a position on the underlying bill. It does support the amendment, however, which we requested, and to the extent necessary, I'm here to provide informational testimony. Because the statute amends the Civil Rights Act, I thought I would begin just with a quick background on that particular act. So the Civil Rights Act was first passed in 1999, and it prohibits interfering with rights and lawful activities of another through actual or threatened uses of force, violence, property damage, or trespass when those unlawful acts are motivated by protected characteristics, including race, religion, disability, national origin, sexual orientation, gender identity, and others. It currently authorizes the Attorney General to bring actions to protect those rights. We can seek civil penalties up to $5,000 per incident or violation, and a restraining order to protect victims, their communities, and further the goals of the Civil Rights Act of protecting those rights and lawful activities. If there is a violation, if an order is imposed and a violation occurs after the fact of that order, we can then pursue criminal charges. So it's kind of an escalating provision if and when a person violates that restraining order. The goal of the statute is to facilitate public protection by creating an avenue through the civil process, to use civil process, to shield victims and their communities from future harm in scenarios where civilly they may not have access to these same protections. So a lot of these things, uses of force, violence, property damage, they're not analogous to the criminal code, although many of those may be crimes. They're more analogous to civil tort claims. And in some of these circumstances, some of the cases we see, the amount of damages may not be particularly significant, or usually just in general with tort claims, the redress is damages. It's not the restraining order. It's not the no longer, I don't want to have contact with this person because of what they've done to me. It is the monetary damages. And that isn't going to protect the public. It isn't going to protect the victim from future harm necessarily. Moving ahead to more recent history. In December of 2017, just about 7 years ago now, then AG McDonald created the Civil Rights Unit to exercise this authority that had been vested with the department. Before that, it had been spread throughout the department, and there were individuals kind of reviewing these cases as they would come in. In 2019, shortly after I was tasked with leading the unit, we promulgated protocols to aid law enforcement in identifying hate, bias, or identity-based conduct to ensure better enforcement of the act, as well as the hate crime sentencing enhancement. Because again, where there's uses of force, where there's property damage, there may be a crime, there's likely a crime that has occurred. So we work very closely with law enforcement because even if they're not calling the AG's office, they might be calling the police department. And so we work with them to make sure that those are identified, they get referred to us, we get a chance to review them, so that way we can determine if and when it is appropriate for us to take action. Since the unit's inception, it has seen an increase in complaints as referred to by others, that 465%. I will say that number pains me a little bit just because it is how many complaints we receive from the public as a whole. It is not necessarily complaints of hate crimes or Civil Rights Act violations. And I'm always very clear when I tell the media that. They leave that part out whenever they report the numbers, though. So I can say I looked in 2024, this past calendar year, we received approximately 215 complaints or referrals from either law enforcement agencies or the public. about 25 or a quarter to a third of those alleged Civil Rights Act violations, or that could be Civil Rights Act violations. So having seen these increases over time, we have added an additional attorney. We've added some additional resources to the unit to be able to kind of bring more enforcement actions, and we have been bringing more enforcement actions as the years have gone along. One thing that sometimes happens, and is very frequent in a lot of these cases, because many of these complaints, I would say the largest set are probably property damage, vandalism. In many of these circumstances, suspects just aren't easily identified, despite the best efforts of law enforcement, either because there aren't, contrary to what we might want to imagine, there aren't surveillance cameras on every building looking at every alleyway or looking on down like every street. And so things can happen and go undetected, or even the people doing these things, they find those remote areas like the Laconia State School property where they can commit these acts and there's nothing that's really going to catch them doing so, because it may be days, even longer, before someone even sees the vandalism to report it. Other times, we're dealing with juveniles and juvenile behavior, and so sometimes that just doesn't get reported because of the confidentiality protecting juveniles, even if we were to bring an action. But we've been bringing more actions as well as working with law enforcement to investigate and identify suspects or actionable offenses. We do trainings for law enforcement across the state. Every police cadet that comes in through the academy gets a 2-hour block of training on hate crimes and civil rights violations, so they can be better equipped to identify these incidents. And we've done trainings for existing law enforcement as well as prosecutors. These cases, when we get them, are our highest priority. We also have authority to bring discrimination actions on behalf of the state, but where these are acts of violence, acts of property damage, we are the only ones who can bring these cases. They're always our highest priority. That would remain the case even if this bill were to become law because of the nature of the offenses there. So looking at this proposed legislation, SB 139, though we're not taking position on creating the private right of action, we were glad to see that the department will receive notice and provide cases of cases when they're filed and the outcomes of those cases. The amendment that we suggested takes it a step further so that we can intervene and ensure that in any case brought by a private citizen, we have the ability to make sure that that full public protection is occurring. It's not just a restraining order that says don't contact the victim, stay away from the victim's home and property. It also will include some of our standard terms such as don't commit future Civil Rights Act violations. If there are other individuals or groups that are being affected, don't go kind of near them when we deal with houses of worship. It's not just stay off the property of the house of worship. It's have no contact with the staff, have no contact with the congregants, because recognizing they may not know all of these people, knowing contact with the congregants to protect those individuals from reoffenses or kind of continued violations that occur as a result of that. So we want to make sure that that remains the case in private rights of action. It doesn't get lost in bringing those actions. The last thing I want to just flag is considering the cost. The one thing here is that, the department, as I kind of noted in the fiscal note here, don't think it's going to be a cost-saving measure for the department. We are still going to be getting these cases. We are still going to be bringing them. If not, we'll probably see more referrals as these private rights get filed, both by folks who are represented by counsel, but people who may not be represented by counsel. We'll get notice of those as well. And we'll have to screen those and work with local law enforcement to see if there are criminal actions that could be brought as well. So at the best, it's cost neutral. More likely, it's probably going to increase the amount of resources that it consumes from the civil rights unit. And I had my 2 other notes here. I mentioned the 465% increase. That's number of complaints total that we received that covers all different things, including things that we don't do, and we have to tell people we don't do that. And I wanted to just kind of push back, well, certainly there's an increase in the number of complaints we receive. Because these are our priority, we do work diligently to keep up with the number of complaints we receive alleging Civil Rights Act violations. So this isn't a circumstance where the department or the Civil Rights Unit is overwhelmed with complaints that it can't take action on, meritorious ones. I'm happy to take any questions.
Nope, you're good.
Great, thank you.
It's so good. No questions. Thank you very much. Does anyone wish to testify who I missed? Beth, you want to come up? No. Okay. Thanks very much. Okay, that'll adjourn the hearing. We're going to take a 10-minute recess and then exec a few bills if you guys can stay. Okay, awesome. I make a motion, we go into executive session.
Second.
All in favor?
Aye.
Aye. Okay, we're just gonna start off because it's my pet peeve bill I wanted to get to, 54.
54?
Yeah, so that was on the, if you refuse to take the breathalyzer, we were increasing the penalties. The substantial portion was from 180 days to 360. It's just one I've wanted to move and just never has moved. So the reason is, it's an administrative safety measure. We want to keep the roads safe. We want to get people into treatment quick. Rehabilitation, lower loss of license. We don't want them reoffending. So the sooner we can get them off and into treatment, the better. But we're having significant problems out on the roads. And that's why I'm moving the OTP. Do I have a second?
Second.
Discussion, further discussion? By others? Yep, go ahead.
With you. And, yes, I'm with you. Thank you very much, Mr. Chair. Would the committee entertain making an amendment to line 10 that would allow for judicial discretion between the 180 days and a year, depending on the severity as far as the judge was concerned?
No.
So.
Okay,
And
well,
if I could-
thanks for talking.
Just for clarification purposes, the administrative suspension is not something that is implemented by the court. So essentially, you would be allowing the court to override that. I'm not sure there's any other division of the law where that's done, so I'm not sure if we want to start with that precedence now. And I'm not sure if we could even do that, but just on a punitive measure, we, in the last, I want to say 8 years, have set up a hardship license, which you only can get once your case has finally reached the final disposition. But I think this is actually less punitive than it would have been had there not been a hardship license opportunity. And I think that some of that impacted my decision.
I have one more thing, this is not intended as a punishment at all. It is
Exactly.
just an administrative safety measure.
Of course.
And,
Senator Gannon?
Yes.
Senator Altshuler is missing the amendment. Are we bringing?
no, we're not doing the amendment.
We're not doing the
No,
amendment.
I'm not bringing the amendment up.
Okay.
Just going straight up OTP. Okay, are we ready to vote?
Yeah.
Okay, all in favor say aye.
Aye.
Opposed?
Nay.
3-1, I'll take it out. Which is easiest?
I don't.
We'll do 141, just, I want to get that done too. Sorry, Cinder, I make a motion of ought to pass on 141. That was the Innocence Project thing, where we were narrowing the exceptions, really tight, really narrow, newly discovered evidence, new science. It would go to the judge of the court it came from, and they would have full discretion on whether it went any further or stopped there. It just, to me, it offends justice just to have a hard line at the 3 years. If there's a new science, new way of reading technology that I don't understand and can't even envision, there could be nothing worse than having an innocent person if we find out that they are such rotting in jail because we never could, the Innocence Project or someone else couldn't move it forward. Any other thoughts?
So, Mr. Chairman, if I may, when it
Yes.
talks about new evidence, it does say, it talks about forensic testing, a new scientific understanding,
Sure.
and evidence that was not admissible at the time of the trial. But it does say includes, but not limited to. So this really could apply to any, I suppose, new evidence that someone uncovers. Now, if you uncover new evidence that completely, and when you use the term exonerates you, it means it shows with absolute certainty you 100% did not commit this offense. There's already provisions to have the conviction vacated. This is different. This is for a new trial, without any limitation on when that new trial, could happen. I mean, it can be 20 years after the case you're asking for a new trial. If you're completely exonerating yourself, although a new trial may be one step you can go, I think getting the conviction vacated is the,
I'm sorry, Senator Reardon, go ahead. I'm sorry, you still going?
I just think that with what we're talking about here, this is really open-ended to any new evidence that someone.
Well, not any new evidence. It would have to be something that would change the disposition of the case. If some minor thing that wasn't important, that wasn't relevant, that couldn't overturn the case, the judge would say, this isn't determinative of giving you a new case. It's his discretion that this would have to be a piece of evidence that could change the whole outcome.
Yes, it's that's the standard for the granting of a new trial.
Yep.
But I'm just saying to do that basically anytime.
Anytime there's new scientific evidence such that rises to that level.
But it's not just that, it's includes but not limited to. I think this is going to create a lot of work.
Senator Reardon?
Thank you. I asked that question of the Innocence Project about what are they talking about? And the example that they actually gave me was shaken baby syndrome, where there are a lot of people that were put in prison when their infants died. And subsequent research found lots of other medical reasons that manifest themselves the same way in a child. And one of their projects was an individual who had spent 21 years in prison and then was always declared his innocence and was exonerated with the new research that came out of Great Britain. And they are looking for other like standards. And so 21 years he was in prison and then was exonerated after that.
So if the person's completely exonerated, though, they still have a way to get the conviction itself vacated. This is asking for a new trial, is what I'm saying.
So I'm not sure what the circumstances were in that case, but perhaps that just doesn't exonerate you because you come up with a medical study, but maybe that is something that can go back before a judge or a judge and a jury to say it's more likely than not that this child had this medical condition as opposed to being actually killed by a parent. So I just don't think we'll come up with all of the hypotheticals. I thought they gave me a great example, but I asked that question.
Okay, I think where we're gonna be, all in favor of the autopass? Did I bring it or did you bring it?
I'll second it.
She seconded. All in favor of the autopass motion?
Aye.
Opposed, anyone?
Nay.
3-1. Tara, do you want to take it out?
Sure.
Awesome, thank you.
So we're not going to do consent with either of these that we've done so far. Going to move consent.
We could with 3-1.
I say keep one, we can't keep 141 off consent.
We can or can't?
I would ask to keep it off.
Sure, that's okay. I'm fine with that. We'll go to, for no real reason. We'll go to 149 relative to the crime of aggravated driving. And I have an ought to pass motion. Do I have a second?
Second.
Oh, yeah, the wrong way driver. Discussion? So,
I have a notation about, and it just have a notation about an amendment. Are we expecting an amendment or?
we
have no
were, but
idea.
it was, no,
Okay, so we're not.
we were, but,
Okay.
Attorney Lehman thought he saw something. And he said, I was wrong, didn't,
There
so
we
that's
go.
why.
Thank you.
You have to have made a motion for ought to pass.
Second.
And second, all in favor of the ought to pass motion?
Aye.
Move consent.
All in favor of consent?
Aye.
I did, I'm sorry, my fault. You want to take it out?
Sure.
149. 268. I think we just did that earlier was that this week? the safety and accountability of drivers under 18 years increase. It's mostly increasing penalties for. Am I in the wrong one? Yeah, 266, I'm sorry. I
266?
can't stay with these dollar classes. 266. So we're increasing penalties for young drivers who are driving horribly. Going way too fast, or doing other activities, driving on suspended licenses, and I believe it graduates up as they keep doing more wrong things. And there are things for judges' discretion in this bill. There's mostly minimums and then not more than. Discussion. I move OTP if I didn't already.
Second.
All discussion, not discussion. All in favor of the ought to pass motion?
Aye.
Deb, you want to take it up?
Move
Under
for consent?
Oh, I'm sorry, move, yeah.
Second.
Second, whatever. All in favor of the consent motion?
Aye.
Aye. Okay, Senator Oshler?
Sure.
Awesome. One to go. This was on competency, and I just never really thought that the bill.
What number?
I'm sorry, 48. Senator Long's bill. I never really thought what we want to do is somehow deal more with the restoration of competency. Didn't think the bill did this. The purpose of the bill to prevent individuals deemed incompetent from standing trial for languishing in jails and mental health institutions when they've committed nonviolent offenses. During the testimony, we heard that low-level offenses listed in the bill are not held in jail pre-trial, so the bill does not impact incarcerated individuals. We also heard testimony that it's not possible to forcibly place someone in mental health institutions, so committing one of the listed crimes. So this bill will not help people languishing in mental health institutions, which was another state purpose of the bill. And that's all I need to really say.
If I can just point out.
Yes, you could.
Mr. Chairman, it says in here that if this were to become law, a motion to dismiss the charges under this paragraph may be made by the prosecution, the defendant, or the court. The court doesn't make motions. So I think that's just, regardless of where you stand on the policy, the court shouldn't be making a motion. So I'm referencing lines 19 and 20.
Thank you.
It just,
Motion to dismiss.
let's just say you have a different scenario, the alleged victim doesn't appear, you have a confrontation clause, Sixth Amendment issue. The prosecution can't proceed with the case. The court knows what's going to happen. My experience is say, counsel, would you like to make a motion? Because they know what I'm thinking. But they don't, the court themselves just doesn't make that motion. So this is the point I'm making. So I think that's an issue. And also, although this would be rare because it's a Class B misdemeanor, we're dealing with a 1-year statute of limitations. I suppose if it's dismissed, I believe it's dismissed with prejudice. You could have an awkward scenario where the person is now competent again, still within the statute, but it's been dismissed with prejudice. So I think there's another problem with the as written. I would support an ITL motion.
So, Senator Gannon.
Yep.
I know you just made a statement about this, and I may have missed this. Could you tell me where there was some testimony from Attorney Stevens from NAMI, New Hampshire? And I'm just, she had pointed out that we don't have a formal restoration process, and therefore a lower rate of restoration. So would this, let's say, just for hypothetical sake, there was there was an appetite for an amendment that would take out the bit about or the court to satisfy Senator Abbott's objection. Is there anything else that that speaks against giving, just setting at least a framework for restoration?
So that is a much more complicated process. I think, I do agree with you that there should be some formal procedure to guidelines on how competency can be restored, which we don't have. Can we do that on a bill with a fiscal note in a short time period?
Well, this allows for, the judicial discretion, which we don't,
Don't we already provide for them? Prosecutors and the judges already have discretion to prevent situations like this. Am I not correct, Senator Abbas?
Well, I think that if the person is not competent to stand trial,
Yep.
you're not going to try that person.
Yep.
Simple as that. You can stay the case or whatnot, but when someone's not competent for trial, they're not going to. When we're talking about Class B misdemeanors, the person they're not incarcerated for a conviction either. So the prosecutor has discretion at any time to just to non-prosecute a case.
but they can be detained. So,
On
we heard, can be detained. We heard testimony that there's somebody who's been detained for they're still detained at Valley Street waiting for a year.
For a Class B misdemeanor.
That's what we have testimony,
So
right? From
So that-
Attorney Stevens. I'm just,
For that to happen under
Yeah.
the bail laws, they likely are violate like the conditions of their release or their probation of some sort. So you could have someone serving time for that, but it's likely a collateral something else. Because the penalty, if convicted, you can't go to jail for it. So I think the bail laws, if you're released on bail, you get arrested for a new offense. But in order for you to be held, it has to be, the only Class B misdemeanor would allow that is drunk driving. And the rest of them have to be either a Class A or a felony. So now, are you violating your parole if you get charged with a new offense? That's a common condition of your parole. So that could be a result of why they're being held. But even if you get charged and it's dismissed, technically the new charge is the violation, not even that it was dismissed. Even if you found not guilty, they still can. They really want to play hardball, they could do that. But if there's a competency issue to stand trial, they're not going to go forward with that trial. But I'm speculating into what the circumstances are.
yeah, we don't have testimony as to what the circumstances were, just that it is, so.
Senator Reardon, your thoughts?
I'm not sure.
Would you guys
I'm-
be inclined to re-refer?
Well, if it's a charge where there's no jail time, the person is incompetent to stand trial, so that's not going to happen. If they're dangerous, there's a process to hold them because they're dangerous. So although we're having this hypothetical conversation about it, I'm thinking that's a lot of people who possibly have mental health issues that pass through the courts, that there's no ability to try them, they're not competent, there's no ability to assess a fine, they're indigent. So I can't think of the scenario where we would do anything else other than dismiss the charges. And I actually have a note here that it might not be, that they might not be dismissed without prejudice. So there's a possibility that the court could dismiss the charge, and if it's within the 1 year statute, that for somehow to get back on their meds or something like that.
If they have them.
So
If they've had.
So if a prosecutor moves to dismiss the case and no process is the term they use, if they did that and it was dismissed and it's now outside the statute of limitations, they wouldn't be able to refile. So it's for all intents and purposes, dismissed with prejudice. It's not.
So I guess we want society to be safe. We want to treat defendants fairly. We don't want people committing crimes and not being held accountable for it. I'm not sure where we check any of the boxes or don't satisfy any of those things. If they're not a danger to society, they're not competent to stand trial. And if they were dangerous, we would be keeping them. I'm not sure why we would want to do anything else. I guess, what is the other scenario that we're not thinking of then? Other than warehousing somebody, which is what we're trying to avoid.
And I understand what you're saying. I don't think that's, I know there was testimony that it's happening in one scenario, again, not knowing all the details, but I don't think if that is happening, I still think this would need a lot of work, but I don't think this is the right bill for it.
And I'm not sure, I disagree with you. Is this new language attempt just to put what's happening in practice into law?
I'm not sure of that. I think it goes beyond what's happening in the real.
Practice now.
And just giving the court the unilateral discretion to dismiss a case, I think that's.
If the prosecutor doesn't.
It's also giving, if on line 24 and 5, it is introducing the discretion of offering an evaluation to determine the appropriateness of involuntary treatment, because we don't, not every case of incompetent is also an involuntary commitment.
Should we do Thursday?
So does this maybe, I mean, should we re-refer to try to tease out some of these questions?
But even a
Next year?
135C hearing, right, that's the involuntary confinement.
Yeah.
That's still not something that I think the court is the one that raises that. Normally that comes before them because someone files something. And I'm saying that the court is not the one that says, all right, we agreed to dismiss this, but I want to have a 135C hearing, right? And now that hearing, they have a right to counsel. There's a lot of.
This is just an evaluation, so there's no evaluation right now, because we have no framework. So this introduces at least we've opened the door that with this incompetency, there may be some mental health issues, right? And so we're leaving open the possibility of some judicial discretion in ordering a mental health evaluation.
So,
Could you live with the re-refer?
yeah, I definitely could. What you're saying is there hasn't been a determination of competency. Line 14 says when a defendant is found not competent to stand trial. So somebody has.
Right, but there's no follow-up. And this, at the end, we're offering the follow-up a little bit.
But that can already be done. That's already available in the law. If a family member wants to file that, I'm not sure if the defendant wants to.
Can anybody file a request for competency?
I think there's some limitations on standing and who could do it, but it is available. I'm not sure if it's appropriate for a prosecutor to do it, because if the case is dismissed, I think their involvement in the case is over. But I know a family member could, a household member can file that. But I don't think it's appropriate for the court to unilaterally decide we're going to hold this type of hearing. I think someone needs to bring something to them, which in many scenarios may be appropriate.
Mhm.
But again, just the court acting on their own, I think it's not.
Okay.
Not appropriate.
I'm good with re-refer. But re-referring somebody finds some answers, right? Yep.
So again, if this had done more, Senator Elsher, with restoring competency, I'd be much more into it. I don't see this as, so I'd rather go with a re-refer. We could work on it.
It's an
That's
if-and.
okay with
We
you.
can do that. Yep.
But even if we re-refer this, I mean, we're just going to end up having to do a replace all. So couldn't a new bill just be filed?
Sure, it could be done.
If we re-referred and somebody says who does this, tells us exactly what the current practice is, it may answer our questions that there's a process in place already. And then this wouldn't be necessary if in fact there's a process in place.
You okay?
I still think if we're going to come up with a procedure, then we would be more inclined, it should be a separate new bill, which I think there's an appetite in the committee for consideration, but I just think what this is doing is really a narrow application, and
We hold it till Thursday.
Sure. I'm okay with it.
I have one more member I can talk to. Okay.
That's fine.
Okay.
I'll withdraw the motion. I can explain the motion.
Motion to come out of executive session.
So moved.
All in favor?
Aye.
Aye. Adjourned. Yeah. Yeah.
Yeah. So maybe what we're talking about is a study committee that
Thank you
studies
guys.
that. Not a.
You got 6 exec. We did 2 earlier.